Peekaboo. Haha, what's up with y'all, man? I'm back, man. Mr. Zach Reacts live stream tonight, man. Tonight we got Oversight Committee, man. These left-leaning radical judges, man. We need oversight on them. Some of these NGOs and also some of these left-leaning lunatic law professors. So I ain't gonna hold y'all, man. Y'all subscribe as soon as y'all come in, man. I appreciate, man. Support the channel. We're trying to build and build and build, and it is what it is. But I ain't gonna hold y'all, man. Let's get into it. I'll be checking in every so often. I'll be in the comment section. Y'all leave a comment, man. All right, I appreciate y'all. Let's go.
Thank you very much, Mr. Chairman. Mr. Chairman. It's great to have this hearing. Thanks for calling it. Thanks to all of our witnesses for being here. Professor Shaw, nice to see you again. Let me just start with you, if I could, Professor Shaw. You talked about the fact that there have been lots of rulings against the Trump administration. That's absolutely statistically true. I disagree with almost all of them. In fact, I think all of them. But the issue of this hearing really isn't the rulings, is it? It's the remedies. Would you agree? And those are distinct things. You may think that the ruling is quite correct, but that's actually not what we're talking about here today. We could have a hearing on that. Maybe we should. But we're talking today about the remedy. And the question is a remedy that binds parties who are not before the court, is that an appropriate thing? I mean, aren't you concerned about judges binding non-parties in their remedies? You may love the ruling, but even if you do, don't you think it's a little bit anomalous for courts to be going out there and binding parties who are not before them? I mean, is that something we want to encourage?
Senator, I think that judges have been issuing rulings that impact non-parties since Marbury versus Madison, right?
So you're not concerned about it?
I'm not. I absolutely think that they can be abused, and
wait a minute. You were very concerned about it just a couple of years ago.
Yeah.
You said in response to a nationwide injunction on the Biden FDA's mifepristone rules, and I quote, "This injunction's a travesty for principles of democracy, notions of judicial impartiality, and the rule of law."
I think I've been consistent today. That was issued by Judge Kaczmarek in a single judge division. They're a problem. Those are a problem.
With him personally? Wait,
no.
So your testimony is if it's issued by Judge Kaczmarek, it's bad?
No, sir.
It's personal?
That is not my testimony.
So is the problem with the injunction? You were criticizing the universal injunction
issued by a judge in a single judge division. I've been very clear today that those are a problem.
By a Republican judge in a Republican division, then it's bad.
No, Senator.
Otherwise, it's fine.
No, Senator. I think that single judge divisions are a problem.
What is the principal difference? I'm looking for a principle. I understand you hate the president. I understand you love all of these rulings against him. You and I both know that's not a principle. You're a lawyer. What's the principle that divides when issuing a nationwide injunction is okay when it's not? When the Biden administration was subject to nationwide injunctions, you said that they were travesties for the principle of democracy. You didn't say the referral to Judge Kaczmarek was a travesty. You said his injunction was a travesty for principles of democracy. Yeah. So, in other words, the translation is just you didn't like the outcome. Is that right?
No, Senator. Look, we're talking about, I don't think Article 3 precludes this form of relief. So we are talking about prudential consideration.
Prudential meaning political?
No.
Then give me, so far I have yet to hear it. You've been questioned by multiple senators. I have yet to hear a principle other than the fact when you like the ruling, you think it's great to apply it nationally, including non-parties. When you don't like the ruling, it is a travesty for the principles of democracy, notions of judicial impartiality, and the rule of law.
Look, Senator, I'll say, I think I am self-aware enough to know that my view of the underlying legal question, I am sure colors my perception of the remedy. I think that we should all acknowledge that. And yet I do think
that why shouldn't we stop nationwide injunctions for everybody?
I think that's
what we're talking about today.
Because I'm not willing to leave without relief non-parties who are injured.
No, you're not willing to leave without the ability to bind President Trump.
No, I think that...
I mean, when it's Biden, it's okay. No. When it's Biden, oh, it's a travesty. When it's Trump in office, it's no holds barred, whatever it takes, right?
I believe in a powerful...
What was it that President Biden's staff said? We've got to do undemocratic, unconstitutional things to save democracy. Why is it the same
I believe in a powerful president. I do believe in presidential power, but power and constraint are not at fundamental odds.
What is the principle? What is the principle? The legal principle You've referenced prudence. You've referenced the judges you don't like. What's the principle of when an injunction binding non-parties, which was never done in this country before the 1960s? And let's see the chart, the Trump chart, which was done really only once Trump came into office for the first time. You don't think this is a little bit anomalous? You don't think that's a little bit strange?
A very plausible explanation, Senator, you have to consider is that he is engaged in much more lawless activity than other presidents, right?
You don't think
you must
this
concede that
was
as a
never
possibility.
used before the 1960s, and suddenly Democrat judges decide we love the nationwide injunction, and then when Biden comes to office, no, actually.
It's Republican appointees as well, Senator,
like
and the 1960s is where some scholars sort of locate the beginning
Can you
of this, but
identify one
others,
before then?
Mila Sahoni, who's another scholar of universal injunction, suggests 1913 is actually the first, and others in the 20s.
The Republic endured for 150 years before there was a nationwide injunction.
Well, the federal government was doing a lot less until 100 years ago. So there's many things that have changed in the last 100 or the last 50 years.
So long as it is a Democrat president in office, then we should have no nationwide injunctions. If it's a Republican president, then this is absolutely fine, warranted, and called for. How can our system of law survive on those principles, Professor?
I think a system in which there are no meaningful constraints on the president is a very dangerous system
That's
of law.
Not what you thought when Joe Biden. That is not what you thought when Joe Biden was president.
Every president
you said that is not what you said.
You
said it was a travesty for the principles of democracy, notions of judicial impartiality, and the rule of law. You also said
the Supreme Court senator agreed 9-0 with me on that.
You also said when Joe Biden was president, you said the idea that anyone would foreign shop to get a judge who would issue a nationwide injunction was just politicians, just judges looking like politicians in robes. Again, it threatened the underlying legal system. People just trying to get the result they wanted. It was a travesty for the rule of law. But you're fine with all of that if it's getting the result that you want.
Sir, the Supreme Court agreed unanimously with me in that case, right? There was no standing. The case should never have been allowed to proceed.
Wait,
the combination of parties without standing and the single-judge division.
No. We're talking. No, they did not. They did not issue a ruling on the nationwide injunction. You criticized the injunction nationwide. Listen,
issued in a case where no one had standing.
Here's the thing. We've now gone 6 minutes, and Senator Kennedy had you for 6 or 7. You couldn't identify a single principled basis. We all know the truth here, which is it's not just you. It's most of my colleagues over here on this side of the aisle, who I respect a great deal, and they were raising very principled objections to the nationwide injunction just 6 months ago, maybe 9 now. And you're probably right. My point is that all that's changed in 9 months is the occupant of 1600 Pennsylvania Avenue. And I realize that my colleagues on this side of the aisle very much dislike that individual, and I realize that you think that the rulings that he has lost are fundamentally sound. We might grant all of that. I disagree with all of that, but we can put that to one side. The question we're talking about here is, should judges, single judges, district court judges, be able to bind non-parties who are not in front of them? And you used to say no, now you say yes. Let's be consistent. I would just suggest to you our system of government cannot survive if it's going to be politics all the way down. Thank you, Mr. Chairman.
Can I briefly respond?
Sure.
I mean, you invoked democracy a couple of times there, Senator. Judges are part of our system of democracy. Democracy is not as simple as majority rule. Judges have always served something of a
You would have it be as simple as majority rule. When you get the majority you like, you're for the nationwide injunction. When you don't, you're not. Thank you very much, Mr. Chairman. This is a great day for the state of Missouri. It is an honor today to introduce 4 outstanding Missourians who are being nominated by President Trump for the federal bench, and we're very proud of the fact that these are President Trump's first judicial nominees from the state of Missouri. Let me start with Missouri's Josh Devine, who is our current Solicitor General. Josh's experience as Solicitor General is wide-ranging. He has litigated in trial courts, in appellate courts, in the state Supreme Court, in federal trial courts, in federal appellate courts, dozens and dozens, and maybe hundreds of times by this point. And any way you look at his record, his success record, it's astounding. Just to quantify it in dollar terms, Josh, as Solicitor General of Missouri, has won in dollar terms. He has a $725 billion, that's with a B, billion-dollar win record for the state of Missouri, including a judgment against China for the harms caused to Missourians during COVID-19 of $25 billion. Josh comes to us from Yale Law School. He's been a clerk at the United States Supreme Court for Justice Clarence Thomas. He worked in the Missouri Attorney General's office, first as a Deputy Solicitor General, where I had the privilege to hire him in 2017, then here in the Senate as Chief Counsel to me, serving on this committee, and then back to the Solicitor General's office now in the state of Missouri. And he's done all of this while serving his wife and family, which is probably the most important service he's rendered. They're here today. His beautiful and brilliant wife, Elizabeth, and their 6 children. And I hope it's okay if I tell everybody that number 7 is on the way. So Elizabeth and the kids are all with us today, and we're so glad to have them. I'll just add one other note, which is something about Josh's personal fortitude. Just a couple of years ago, while he was in the midst of these very high-profile, high-intensity, high-stakes lawsuits, Josh suffered a catastrophic accident and was confined to a wheelchair. His early prognosis was he may not ever walk again. But Josh fought to regain his ability to walk, just as he has fought for Missourians in court day in and day out. And you'll see here in a moment when he walks to the table that he has now fully regained his ability. We thank the Lord for that, but we also look at his tenacity and the character that it displays. Like Josh Devine, Maria Lanahan comes to us from the Missouri Attorney General's office. She's a graduate of Gonzaga University, the University of Chicago Law School, and she has been a force as the principal Deputy Solicitor General in the state of Missouri. Here again, Maria's experience is wide-ranging, litigating in courts at every level, trial courts, appellate courts, federal courts, state courts. And she, before joining the Attorney General's office, she had elite federal clerkships. She served in private practice. She did in-house counsel work. I'm really taken with what Missouri Attorney General Andrew Bailey, who's here today, by the way. We welcome you, General Bailey. It's great to see you. Andrew said that Maria was, in his view, one of the finest legal minds in America and one of the finest legal minds he has ever served with. It's a delight to see Maria here today. Zach Bluestone, his legal career has taken him literally everywhere, and he has excelled everywhere he's been. He's had stints at Georgetown, the University of Oxford, Harvard Law. Zach is surely among the best educated lawyers that we'll see on this committee. He clerked on the 8th Circuit Court of Appeals. He has worked in all 3 branches of the federal government. He has significant trial and appellate experience in both federal and state court. He worked ably by my side in the Missouri Attorney General's office as we work to protect the Constitution and the law, and his record as a prosecutor is absolutely second to none. And finally, the Honorable Chris Stevens. I know Senator Schmidt will want to say a lot more about Judge Stevens, so let me just say briefly, we're so proud that he is a Missourian through and through. He's a 6th-generation Missourian who did his undergraduate work at the University of Missouri, graduated from the University of Missouri School of Law, spent 15 years as a federal prosecutor in our state. I'm told he's one of the best federal prosecutors we've ever had in the state of Missouri and is now serving ably on the bench in the state of Missouri. He was first assistant to Senator Schmidt, and he is going to make an absolutely terrific federal judge. I will just say finally, Mr. Chairman, in closing, these are 4 tremendously, immensely, superlatively qualified nominees. And I look forward to seeing them approved by this committee and confirmed in due course on the floor of the Senate.
I'm going to yield my time now to Senator Blackburn. Just before I do, I just want to just clarify one thing to make sure I understood your answer, Mr. Hermendorfer, to my friend Senator Durbin's question. He's asking about the CASA case. He talked about your brief filed in the CASA case. The state of Tennessee was the party they're filing. Is that correct?
That's right, and there's no filing that I would ever make or have made that would not reflect the interest of Tennessee.
You're representing your clients. This is the state of Tennessee. You work for the state of Tennessee.
That's correct. I'm a state public servant who has a client and adheres to the direction of my appointed boss, the Attorney General.
And I think your amicus brief also spent a good deal of time arguing that courts do not have Article III power to bind non-parties. In other words, it was about universal injunctions or nationwide injunctions. Wasn't that a core piece of your amicus brief?
That was an important part of the brief.
Yeah, I thought so. Ms. Hermendorfer, we're going to go to Senator Moody, but let me just ask you beforehand, just to make sure that I'm clear. My colleague was just asking about the number of cases that you've tried to a jury and cross-examinations performed before a jury and direct examinations performed before a jury. What court are you being nominated to?
The 6th Circuit Court of Appeals.
The Court of Appeals. Do you have any appellate experience at all?
I have litigated probably over 100 appellate cases.
Over 100 appellate cases. How many different courts of appeals, how many different circuits have you argued or litigated in front of?
I've Argued in front of 9 circuits in the Supreme Court.
Nine
Not
circuits.
argued, litigated.
Litigated. 9 circuits in the Supreme Court, over 100 appellate cases. That sounds like quite a bit of experience to me. Ms. Herman-Dorfman, let me just stay with this question about the Title IX litigation that Senator Welch was just asking you about. Tell us about the Title IX litigation that you carried on behalf of the state of Tennessee.
Sure. In April of 2024, the Department of Education issued a final rule interpreting Title IX, which of course bars discrimination on the basis of sex in any federally funded educational program, interpreting that language to bar discrimination on the basis of gender identity and other, quote, sex-based characteristics. And as part of that rule, which again was a rule, did not go through Congress, the Department of Education informed all federally funded educational institutions from pre-K through college that sex-separated spaces like locker rooms and bathrooms must instead be assigned by gender identity and not sex. And in similar ways, sex-separated programs like intramural sports and others fell in the ambit of that rule.
Let me just stop you right there. I want to make sure we understand the significance of this. What you're saying is that the Biden administration used an administrative process to interpret a law, a landmark law passed by Congress, Title IX, to interpret it, to require your state, and indeed every state, to allow men, biological men, into women's locker rooms, to allow men, biological men, into women's sports, to allow men, biological men, into any space that a biological woman might otherwise claim under the ambit of Title IX. Is that correct?
That's correct.
And so you litigated on behalf of your state to preserve. Would you say that Title IX is a landmark piece of legislation?
Absolutely.
Would you say that Title IX took years, indeed decades, to achieve?
That's correct.
Would you say that Title IX is a cornerstone of women's sports and the ability for women to have the same opportunities as men at the collegiate level and indeed every level, to have sports opportunities, athletic opportunities, leadership opportunities? I mean, is this an important statute?
It is, and for a former athlete, it hits especially close to home.
Yeah, you've lived it, have you not?
That's right.
So when the Biden administration issued a rule, not a law, not passed by this Congress, a rule that would have completely changed the meaning of Title IX, would you say that that's a pro-woman agenda?
We argued that the considerations of women were not adequately accounted for in the rulemaking process, and virtually every court to consider that rule, almost a dozen, agreed with the position Tennessee advanced on behalf of 6 states in our litigation.
Every court virtually to consider the litigation agreed with your position. Is that correct?
Including the Supreme Court in a stay application.
Including the Supreme Court of the United States. Would you say it is fair to call the effort to undermine a landmark piece of legislation for women that you yourself benefited from, that fair and equal opportunity? Would you say it's fair to call that a dark chapter in the history of this country?
I mean, certainly on behalf of Tennesseans, we thought that rule was unlawful and inappropriate, and we were happy to succeed in the litigation against
Well, I just want to tell you, I'm happy you succeeded in the litigation. As the father of a 4-year-old daughter, I'm delighted that you succeeded in the litigation. I want to thank you on behalf of her and my whole family. I want to thank you for going to battle for our daughters, for going to battle for the women you played sports with, for standing up for this landmark legislation, and for fighting it. And yes, I want to say it was indeed a dark chapter. The last 4 years have been a hellacious chapter in the Department of Justice. Those aren't your words, those are mine, to be clear, but I think it's absolutely a fact, whether we're talking about the assault on women's rights and Title IX context and others, where we're talking about the assault on religious believers. Let's not forget, this is the Department of Justice that recruited informants into Catholic parishes in this country. If that's not a dark chapter in this country's history, I don't know what the heck is. This is a Justice Department that activated the counterterrorism division against parents who went to school board meetings. If that's not a dark chapter, I don't know what is. This is a government, an administration the last 4 years that collaborated with the biggest corporations in the world to censor speech they don't like and then lied about it. If that's not a dark chapter, I don't know what is. In fact, I'd go so far to say it is the worst chapter the worst in the history of the Department of Justice the last 4 years. Those are my views, not yours, Ms. Hermendorfer, but I will just say when it comes to the litigation that you carried out on behalf of the state of Tennessee, I think you did a great service, not just to Tennessee, but for the nation, and I want to thank you for it. Ms. Hermendorfer, thank you for your testimony. You are excused. And with that, I'll invite the 4 district court nominees to come forward to the witness table, and we'll take just a moment here, and we'll administer the oath and then begin the second panel. All right. It is the custom of this committee to administer the oath to all nominees who come before the committee, and you're all standing and ready to do it. So I'll stand with you if you'd raise your right hand and repeat after me. Do you swear that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? You may be seated. Well, we welcome all of you here today. It is our normal process, if you so desire, to allow you to introduce any folks who are with you, including your families, and then to give a brief opening statement. And we'll just go down the panel. We'll start with Mr. Bluestone and then proceed all the way down to Judge Stevens. Mr. Bluestone, the floor is yours.
Thank you, Senator Hawley. I'd like to start by thanking Chairman Grassley, Ranking Member Durbin, and the committee for holding this hearing. I'm also incredibly grateful to the President for the honor of this nomination. To you, Senator Hawley and Senator Schmidt, thank you for the kind words in your introductions. Thank you for your support throughout this process. And thank you so much for the trust that you both placed in me as a deputy solicitor all those years ago when you were both serving as Missouri Attorney General. Over the last few months, I've thought a lot about relationships and community. This process has reminded me of just how blessed I am with the people in my life. They are absolutely the reason I'm here today. Fittingly, the opportunity to serve my community is the reason I want to become a federal judge. I can think of no better use of my talents to make a meaningful impact on the lives of those around me. I regret not having time to recognize everyone who's gotten me here, but I'd like to highlight just a few, starting with 4 key mentors: Senator Jim Talent, John Sauer, Jeff Jensen, and Judge Ray Grunder, who's here today with his wonderful wife, Kim. Judge Grunder is a rare combination of brilliance and humility, and he's a model I'll strive to emulate if confirmed. I'm also lucky to be joined by 3 lifelong friends, John, Todd, and Barath, and I owe my co-clerk, Daniel, a huge debt of gratitude for his support. As for family, it means the world to me that my brother Alex and mother-in-law Shannon have traveled so far to be here, and there's no distance that my mother would not have, that would have kept my mother from coming. In many ways, today is the culmination of all the work she put into ensuring that I had the educational opportunities that my parents never did. I also have her to thank for my faith and commitment to family. My mom's partner, John, is here as well, and I'd like to recognize him for his service to our country, both as a Marine in Vietnam and through his career with the FBI. My biggest supporters are behind me, my wife Abby and our little bud Ezra, who's been instructed to cry if I get any tough questions. I'm looking in that direction, Senator Kennedy. I actually met Abby when we were clerking in the courthouse where I hope to serve, and she's been a pillar of my life ever since. She's showed so much strength and devotion as a mother, and I'll never be able to repay her selflessness over the last few months, especially managing travel logistics with the baby, despite having her own major oral argument in St. Louis yesterday. Finally, I'd like to recognize my dad, Randy, who we lost to a battle with leukemia over almost 20 years ago. My dad's fearlessness and grit in starting a business are something that I'll always admire, particularly after having helped run that company after his passing. My dad often had some choice words for his lawyers after getting legal bills, but I know he's looking down today with a lot of pride. Thank you for giving me a few minutes to recognize those who got me here, and I look forward to your questions.
Thank you very much, Mr. Bluestone. Mr. Devine.
Thank you, Senator Hawley. I want to thank Chairman Grassley and Ranking Member Durbin for holding this hearing today. I want to thank Senator Hawley and Senator Schmidt for all the support you've provided to me during this process. And of course, most of all, I want to thank President Trump for giving me the honor of this nomination. I'm joined today in spirit and in person by too many to name, but I'll mention a few. My wonderful parents, James and Susan, are here. So too is my wife of 15 years. As Senator Hawley mentioned earlier, Elizabeth is pregnant with our 7th child. We have been truly blessed. The other 6 children are here as well. You haven't heard from them because the younger 2, the boys, have been asleep the last 2 hours. 15 years as a husband and 13 as a father has taught me much more than I ever learned in school. Alice, for example, our miracle child, had open heart surgery when she was just 2 months old. And grappling with the many challenges she has faced since then has taught us the virtues of patience, prayer, and perspective. On a professional level, I'm especially grateful to the Attorney General of Missouri, who's here today, Andrew Bailey. When he hired me as Missouri Solicitor General, I knew I was being asked to fill big shoes. My predecessor, after all, was John Sauer, who is now the U.S. Solicitor General. It has been a privilege to serve the people of Missouri these past years. And sitting here today, I'm reminded of what Justice Ginsburg told this committee a few decades ago. What has become of me could happen only in America. My grandmother, born into poverty overseas, never had a day of education in her life. My dad was luckier. He did miss several years of school, but Grandma eventually pinched enough pennies to bring them over here to America. And once here, she learned English by watching American soap operas. She made a living cleaning people's homes, and she did her best to navigate the anti-Italian discrimination that was all too common at the time. Today, barely a generation later, I sit here before this august body, having been given extraordinary opportunities, both professional and educational. But the most extraordinary thing about my family's story is just how ordinary it is. No other country provides so much opportunity to so many, and that is one reason I've dedicated my career to a life of public service. My dedication to public service was reinforced a year ago when a life-threatening accident put me in the ICU and left me unable to walk. For 6 months, I was confined to a wheelchair and then a cane. I'm still recovering to this day, but those are the kinds of experiences that humble you, and they're the kinds of experiences that broaden your empathy to those whose trials and tribulations last not just a season, but a lifetime. Fortunately, although we come from different walks of life, the law promises equality. I had the privilege to clerk for a judge who, when he was Attorney General of Alabama, gave a speech condemning and rebuking the segregationists of that state's past. While lesser men like Governor George Wallace had promised to thwart the Constitution, Attorney General Bill Pryor, 4 decades later, promised the opposite: equal under law today, equal under law tomorrow, and equal under law forever. If confirmed, that is how I will judge. I look forward to answering the committee's questions.
Thank you very much, Mr. Devine. Ms. Lanahan.
Thank you, Senator Hawley and Senator Schmidt, for your kind introductions and support. I'd like to start by humbly thanking President Trump for nominating me to this position. Thank you, Chairman Grassley, Ranking Member Durbin, and all the members of this committee for the opportunity to address the committee today. I also have many other people to thank who are here supporting me. Thank you to my husband and best friend, Michael Lanahan, who's here. Michael is responsible for introducing me to the great state of Missouri, which I have grown to love and have since devoted my career to. My oldest son is also here. He is 7 years old, and my other 2 children, 5-year-old and a 1-year-old, are not here because I was not so sure that they would be able to abide by Senate decorum. So they're at home with Michael's parents, and I'd like to thank Kevin and Kathy Lanahan for taking care of them. Thank you to my parents, Kevin and Ann Hassett, who are here. I would not be who I am today without their support and guidance. Thank you also to my siblings, and especially to my brother Kevin, who made it out here, and for bringing his family with him. That includes my sister Adriana Hassett, who is a newly minted American citizen, their children, and Audrey's mother-in-law, Susana Ibanez Cerda. Thank you to my friend Laurel Sagarts, who is here and who is an adoptive aunt to my children in St. Louis. And I would also like to extend my thanks to the two judges who I clerked for, Judge Grunder, who is here today with his wonderful wife, Kim, and Justice Zara, who was unable to make it today. These two judges have greatly impacted my understanding of what a judge's role should be. They are both committed to following the law as written and fairly and impartially resolving legal disputes, regardless of a party's background characteristics. I also want to extend my thanks to Missouri Attorney General Andrew Bailey, former Missouri Attorney General and now Senator Schmidt, First Assistant Attorney General Jay Atkins, my boss Josh Devine, who is next to me, and the many other colleagues who I have worked with at the Missouri Attorney General's office to serve the people of the state of Missouri. And finally, thank you to everyone else who has helped me and supported me along the way, including my many family members, friends, teachers, mentors, and former colleagues at Thompson Coburn and Charter Communications. I am honored to be nominated for this position, and if confirmed by the Senate, I pledge to decide cases fairly and impartially according to the rule of law. Thank you.
Thank you. Judge Stevens.
Thank you, Senator. Thanks to Chairman Grassley. Thanks to Ranking Member Durbin for holding this hearing. Thank you, Senator, for chairing the hearing. Also want to thank all the members of the committee who are here today for their attention and their time. Also, of course, Senator Hawley, Senator Schmidt, I thank you for your support as well as for your kind words earlier. Frankly, I'm humbled. I also want to thank my family who are here today. First and foremost, my wife, Lee. My wife is my rock. I want to thank her for her support over the years, for her sacrifice, for her grace throughout my career and at this time. Also, my children. Our oldest boy, Jack, is here, our son, Hank, and our daughter, Mary Rose. In all candor to the committee, Mary Rose expressed this morning that she really didn't want to come because this is boring, and I quote. But she is here, and so far, so good. I also, of course, want to thank my parents. Ed and Melita Stevens are here today, and I can't begin to thank them for all they've done for myself and my siblings as children and all the way up through till today. They've been a great example of great Americans, great citizens who've raised their children, loved them, and supported them through thick and thin. I'd also like to thank my law clerks, Clayton Watts and Tyler Dodd. My law clerk, Clayton, is here today. He's agreed to continue on for another year serving with me, regardless of which court I happen to be on at the time. So I'm glad that he could make it here. I'd also, if I could, like to remember one other person that's not here today, my maternal grandfather, Edmund W. Albright. He was a self-made lawyer in St. Louis. He put himself through law school, hung out a shingle, and took whatever case came in the door. As a young man, he taught me to love the law and our profession. I think of him all the time. Today, I'm wearing his watch, which has kept time for me throughout my career. I have his portrait in my chambers back in St. Louis, and I wish that he could be here today for this moment. I also would like to talk a little bit about my career to this point. I have the privilege of being a judge, a state judge in Missouri on the Missouri Court of Appeals Eastern District. I was appointed to that position in 2021 pursuant to the nonpartisan Missouri court plan. Before that, I had the honor of serving as First Assistant Attorney General to then Attorney General Eric Schmidt of Missouri. It was a great privilege. A lot has gone on, Senator, since our meeting at PJ's. I will say, if I could, that I'm glad we met at PJ's and not at Cracker Barrel. I understand that some attorneys general met with staffers at Cracker Barrel, which is, I love Cracker Barrel, but PJ's is the place in Kirkwood. Before that, I was in private practice at several points in my career, early in my career and in later years. And so what that means basically is that I've handled civil cases, I've handled criminal cases, I've appeared in federal court and state court, and I, particularly with regard to the United States District Court for the Eastern District of Missouri, Senator, as you acknowledged earlier, I was an assistant U.S. attorney there for 15 years. I would get up from my desk on the 20th floor of the Thomas F. Eagleton Courthouse, go down a few floors to see the Article III judges or the magistrate judges on at least a weekly basis. So I can tell you that if this body deems fit, then my returning to the U.S. District Court for the Eastern District of Missouri would be like coming home. So I appreciate the opportunity. I thank you for this hearing, and I look forward to answering your questions.
Thank you, Judge. We will start now the questioning. I will lead us off. Mr. Bluestone, let me just start with you. We'll just go down the panel. You are currently a violent crimes prosecutor in the United States Attorney's Office in the Eastern District. Tell us a little bit about the work that you do, the kinds of cases that you prosecute, and what you've learned from that experience.
Thank you, Senator Hawley. Being an AUSA in the Eastern District of Missouri has been probably the most fulfilling job that I've had. It was commended to me by Judge Grunder. And frankly, before I clerked for him, it was not something that was really on my radar. But as both of my home state senators are aware, there has been a violent crime epidemic in the city of St. Louis, in particular, and the area surrounding it. And it has been so gratifying to be able to do something about that. I prosecuted carjacking offenses, armed robberies, other gun crimes, drug crimes, have been involved in white-collar investigations as well, and the work is extremely rewarding. I will say I fully appreciate the importance of every single case that would come before my court if I were so fortunate to be confirmed. Having seen probably north of 100 cases myself, it's incredibly significant to the defendants who would be appearing before me, the victims, their families, law enforcement who were involved. And I take that responsibility very seriously now, and I would then too. I would also note that in addition to being a violent crimes prosecutor, I also serve as our district's appellate chief. So I handle my own cases certainly, but also am responsible for overseeing every appeal, both civil and criminal, that comes through our office.
Is it safe to say, Mr. Bluestone, given your experience as a federal prosecutor, the volume of cases that you've seen and handled, that you know your way around a courtroom?
I would like to think so.
We would like to think so too.
Supervised more than 1,000 cases, and as I mentioned, handled more than 100 of my own.
Fantastic. Mr. Devine, let's talk a little bit about your experience. You are the Solicitor General of the state of Missouri. If you had to ballpark it, this may be tough, but if you had to ballpark it, how many cases would you say that you have litigated just in your role as a Solicitor General? You were Deputy Solicitor General for several years, but let's just leave that to one side. Just as SG, how many cases did you get?
I mean, it would be impossible to know. It's in the hundreds of cases that I have supervised or personally litigated myself. As Solicitor General, I oversee the appeals for 200 attorneys in the office. We're getting a lot of appeals that are coming through that we're supervising on a daily basis. I also have a second job, not just Solicitor General, but also the Director of Special Litigation. And so I'm in charge of the unit, the trial unit, that is tasked with taking some of the most complicated matters that the state of Missouri is dealing with and taking those matters to court, to trial court especially.
So in these dual roles, you have represented the state of Missouri in trial courts.
That's right.
And in appellate courts.
That's right.
And in the state Supreme Court.
That's right.
And in the United States Supreme Court.
That's
right. You've handled some of the office's most complex matters, most complex litigation. Give us one example of a piece of complex litigation that you have handled and what you learned from it.
Yeah, I think the student loans cases that the office argued, we've now had 3 of those cases during the previous administration. Those were very, very quick cases. The administration at the time was trying to cancel hundreds of billions of dollars in student loans. We felt that was unlawful. There wasn't any statutory basis for that. The courts ultimately agreed with us in all those cases. But it was a very, very quick moving thing, and we needed to move quickly to ensure that there wasn't permanent irreparable harm. So one thing we did in one of those cases, we actually sued before the rule had been published, which is a pretty novel thing to do, and we were able to come up with an interesting argument that ultimately prevailed in court for why we were able to do that. We showed that there was irreparable harm. $200 billion was about to go out the door, and we ultimately prevailed in that litigation.
And your success record is hard to argue with. I mentioned it in my opening statement, what you have won in judgments for the state of Missouri through the litigation you've handled totals in the hundreds of billions if you add it all up. I mean, is that correct?
That's right. I think about $700 billion.
$700 billion. That's pretty good, General Bailey. That's pretty good. Ms. Lanahan, in my expiring moments here, let me just ask you to say a word about your extensive and varied legal career. You're the principal deputy Solicitor General now for the state of Missouri. If you had to ballpark, how many cases would you guess that you have handled in trial courts, appellate courts? You know, put them all together. I mean, what would it be?
Certainly upwards of 50, and I have also been in charge of many of the appeals in our office. I oversee directly at least 1/4 of the appeals, and I review them before they are sent in, and I've been doing that for the last 4 years or so. And we have numerous appeals out of many groups. So that's employment law, and you have to remember that when you're doing an appeal, you're not only dealing with the trial court issues and whether what the trial court got it right, but also the appellate issues, which is a whole nother layer of separate issues on top.
Very good. Well, Judge Stevens, I wanted to ask you a whole bunch of extremely difficult questions that would have really been impossible to answer, but I'll leave that to Senator Schmidt. But first, Senator Durbin. It's going to be Senator Schmidt's turn, but can I just ask Mr. Devine, are you running for office?
No, Senator, I've never been a political candidate.
Are you seeking the nomination of a party or the approval of voters?
No, Senator.
You've been nominated to be a judge, is that correct?
That's correct.
Will you be able to faithfully follow the law as you understand it?
Absolutely, and in fact, in my day-to-day, when I'm advocating the interests of the state of Missouri, I set aside my own personal beliefs every single time I'm advocating the interests of my clients.
And what's the controlling Supreme Court case on the life issue now, as you understand it?
The Dobbs decision.
Will you follow it faithfully?
Absolutely.
And on that note, questions for the record may be submitted until June the 11th at 5 p.m. Thank you to the nominees, and with that, the hearing is adjourned.
Would any of you advise a client to defy a federal court order?
No.
None of you would? How about you, Professor?
I mean, under most circumstances, we follow the government and private parties follow court orders. I suppose it's not, I would not rule out ever the possibility that in a sufficiently egregious order, there should be some consideration of whether there's a way.
So in some cases,
I think it's a qualified answer, yes.
In some cases you would.
In an extremely narrow band of cases, I think it would be considered, yes.
Okay. Do any of you think that nationwide or universal injunctions are not being abused?
I'm not sure what if I may, Senator, I'm not sure what the time horizon of the question is. I don't think that there could be good faith disagreements about the correctness of some of them, but I have not seen in the last 4 months abuse. No.
I've read your stuff and I've read your writings, and I don't want to get bogged down with this, but I have little respect for your opinion because I've read your stuff. When someone is in the White House that you agree with and someone gets a universal injunction against him, you don't like universal injunctions. You called them judges acting like they're politicians in robes and judges looking like crass political actors. But now that President Trump's in the White House, who you dislike, you think that universal injunctions taste like pumpkin pie. So I have to discount what you say because I think you act on your political beliefs. And I worry that that's what you're teaching your kids. So I'll leave you out of that. Do you think nationwide injunctions are being abused?
Certainly, Senator. I think that is.
They're being abused by both sides, aren't they?
Yes, Senator.
Both Republicans and Democrats are forum shopping, aren't they?
Certainly.
Professor, do you disagree with that?
I think both sides are abusing them. I agree.
Okay. Both sides.
Yeah.
There are no clean hands here. Now, your suggestion is that when a federal judge issues a nationwide injunction, there should be an automatic stay and an expedited right of appeal. Is that right?
Yes, sir.
Do you disagree with that?
I haven't given enough thought to have a position on it, Senator.
I suspect, Professor, your answer will be it depends on who's president.
No, Senator.
Let me ask you about this. What if we had a rule? I was reading an article the other day. I'm not suggesting it. I just want your opinions. That said, if a president, any president, issues an executive order, let's say, that clearly violates settled Supreme Court precedent, that a federal judge can't issue a nationwide injunction. For example, if a federal a president issued an order that said no one in America has right to counsel any longer, including but not limited to, in a felony case, having the government pay for your lawyer if you can't afford it. That clearly violates settled Gideon v. Wainwright. In that case, a judge has no authority or does have authority to issue a nationwide injunction. But in a case where the law is unclear, a judge should refrain from that. Now, obviously, we'd have to trust our judges, but we're supposed to be able to trust them anyway. What do you think about that?
I don't agree with that, Senator, because I think universal injunctions transgress the limitations under Article 3, even if the underlying merits are clear.
I happen to agree with you. I don't think there's any basis under Article 3, under Supreme Court precedent, under the English common law for nationwide injunctions. I think politicians have helped judges, and many judges are politicians, to just make it up. And many of them are like Professor Shaw here. If they like the president, they're against nationwide injunctions. If they don't like the president, they're for him. Professor, let me ask you this while I have you. On April 22nd, 2024, you said there are some members of the Supreme Court that are evil. Which justices were you talking about?
I'll take it your word, Senator. I don't recall using that word, but.
All right, here's what you said. You were talking about the majority opinion in Muldrow v. City of St. Louis. You said, quote, Justice Kagan, will she be able to control the opinion's future distortion by her evil colleagues? Probably not, end quote. Who are you talking about?
Sir, I'm very skeptical. If there's a transcription, it was probably a transcription error. I do not think I said.
No, you said it. Why don't you own up to it? Which you call some of the members of the Supreme Court evil. Now, which ones do you think are evil?
I would have to refresh my recollection. I've been very critical of some members of the Supreme Court.
You made that statement, aren't you?
I'm
you're an officer
Senator, it doesn't sound like something that I would say.
You know what I'm embarrassed at? That you're teaching our kids.
I don't refer to Supreme Court justices as evil in the classroom,
on
sir.
On your podcast, April 22nd, 2024.
Okay, well,
big as Dallas. And you're an officer of the court, and you're here advising us to be respectful to federal judges, and you say they're evil members of the United States Supreme Court? Gag me with a spoon. You're part of what's the problem in all of this.
Thank you, Senator. Congratulations to the nominees. Thank you for being here. Mr. Woodward, let me start with you. You and I had a nice chat the other day. I appreciated the visit. When we were talking about the civil division, you referenced some tightening up that you believe needed to happen, and you brought up in that context the Mifepristone case. So I just want to drill down on this for a second. 2 weeks ago or so, the Department of Justice entered and filed a motion in the Mifepristone case in the Northern District of Texas. This is a Missouri case where the state of Missouri and some others are seeking to put back in place the safety protocols for the abortion drug that existed before Joe Biden removed them. The Department of Justice attorneys from the civil division filed a motion in that case seeking to have the case dismissed. Is it your understanding that that was a mistake? What's your view of this? I mean, you raised this case to me.
Senator, thank you for the question. As you can appreciate, it is long-standing policy of the Department of Justice not to comment on pending cases. Those briefs do speak for themselves. The reason I've raised that case with you is because we were having very helpful discussion about the fact that litigation should be holistic, and that as the Department of Justice continues to litigate on behalf of the president, there's an obligation, a duty even, for us to communicate with those with whom we're litigating against. We should be personal in our litigation. We should speak to those with whom we are litigating, and we should try to come to an agreement. We don't always have to resolve our disputes in court.
Which did not happen in this case. Is that the thrust of it?
That's correct, Senator.
In other words, the Department of Justice did not work with the state of Missouri. I have to tell you, though, I'm surprised and concerned by the department's decision on the merits in this case. And I've said as much to your soon-to-be boss, the Attorney General. I frankly don't understand it. And I'm sure this case isn't going away. I mean, the Department of Justice said that they did not think venue was appropriate. So let me just ask you, if the states refile in another venue, is the department going to oppose the states on the merits? I mean, is the department actually going to defend Joe Biden's pro-abortion regulations?
Senator, thank you for the question. I have had discussions with the Attorney General about this case in my role as counselor to her presently. Of course, it would be inappropriate for me to comment on those discussions. What I can tell you, Senator, is that if confirmed, we would look very specifically at every case to have been filed by the Biden Justice Department and ensure that those cases are appropriate, and then also ensure that we are taking the right track in those cases. And so I'm happy to talk with you and your colleagues about that case and any other case if confirmed.
As you, I hope, know, before President Biden, mifepristone, the abortion drug, had long had a series of safety protocols attached to it ever since it was first offered in the United States over 20 years ago, including requirements that a physician be the one to dispense the drug, that a physician screen for ectopic pregnancies, that a physician be present to provide emergency care if necessary. President Biden removed all of these, and now the drug is available. You don't have to be a physician to prescribe it. It can be sent through the mail. Telehealth providers from foreign countries are now providing this drug. And it doesn't matter as a consequence what any state or voters in any state decide. The voters of my state, for example, any limits on the drug imposed by voters of a state consistent with the Dobbs decision is automatically overridden by what Joe Biden's FDA decided to do. So this is a matter of extreme importance. And I just point out 70% of abortions now in the United States occur because of this drug, which can now be administered totally unsupervised. Let me just ask you, are you familiar with the Ethics and Public Policy Center's recent survey of mifepristone prescriptions? 865,000 mifepristone prescriptions over a 5-year period. Have you seen that study, Mr. Woodward?
Senator, I apologize, I have not seen that study.
Well, let me just bring you up to speed. What the study shows is that over 10% of women who are prescribed this drug, again, without physician help or aid, over 10% of these women experience a serious adverse health event. That means an infection, hemorrhaging, a life-threatening event, sepsis, that leads them to go to an emergency room. That is 22 times higher than what the FDA label currently admits is the risk of a serious adverse health event. This is the largest study of mifepristone done, I think, ever. 865,000 separate prescriptions were studied. So my point is this: the safety needs are extremely real. They are pressing. The rights of the states to protect their citizenry, I think, is extremely well-founded and well-developed, by the way. I mean, they are seeking the right relief in the right courts. And I just hope that the Department of Justice will do as you were saying a moment ago. I hope the Department of Justice will work with these states and will also vindicate the rights of voters to decide these issues and the rights of states to protect their citizens. I just can't imagine why the department would want to defend the abortion regulations of Joe Biden, who was the most rabidly pro-abortion president in American history. Very different than our current president, who has been the most pro-life president in American history.
Senator, I appreciate the question. As in the wake of Dobbs, I agree. The law is quite clear, and I'm going to sound like a broken record, but the President of the United States has said time and again he will follow the orders that come down from the Supreme Court.
Let me ask you here about one other religious liberty issue. Are you familiar with Mark Houck? Does that name ring a bell? Do you know about this case, Mr. Woodward?
I'm sorry, Senator, I'm not familiar.
Well, that's all right. I think we've got a picture of Mark. Mark Houck is a pro-life demonstrator, peaceful demonstrator, a Pennsylvania man. Here he is with his family, his kids. They're at Mass there. He's a faithful Catholic. Mark Houck took one of his boys, pictured here, to an abortion center to go and walk on the streets, pray, and offer any counsel to any women who might voluntarily want to receive it, pray with them, etc. For this, he was arrested by the United States Department of Justice. They sent a SWAT team to his home in the early hours of the morning in rural Pennsylvania. They detained his children. They used the full SWAT regalia, including semi-automatic weapons, rifles, and so forth, to take him into custody. He was taken into custody. He was charged like a criminal under the FACE Act. He was acquitted by the jury, which is truly remarkable. I want to emphasize the state of Pennsylvania had the opportunity to charge Houck. They didn't do it because they didn't think, liberals in Pennsylvania didn't charge him because they knew there wasn't a case. The Biden DOJ charged him anyway, treated him like a terrorist, and a jury acquitted him, thank the Lord. Now, Mr. Houck is suing the Department of Justice for what they did under the Biden administration. So far, DOJ is opposing his suit. Doesn't this seem like something to you that should be settled? I mean, shouldn't this man have his name cleared? I want to emphasize the jury acquitted him, but shouldn't this man have his name cleared and have DOJ admit that what the Biden administration did to him was just dead wrong?
Senator, in my practice over the last 4 years, I saw firsthand how the Biden administration weaponized the Department of Justice, and there is no place for weaponization at the Department of Justice. I can assure you that we will look at every single case, to ensure that there is no weaponization at the Department of Justice. I look forward, if confirmed, to working with Deputy Attorney General Todd Blanche, to Attorney General Pam Bondi. We will find those cases and we will resolve them.
Good, I'm glad to hear that. I think Mr. Houck deserves to have his name cleared. I think he deserves more than an apology for what Joe Biden did to him. He deserves recompense, he deserves restitution, and he deserves to get what you have gotten for your clients, which is an acknowledgement that what the government did to them is wrong. What the government did to him is wrong. It was a flat out religious persecution, nothing but that. Joe Biden trying to send a signal to every religious believer and every pro-life believer in this country: don't you dare exercise your beliefs in public, or we might come with a SWAT team and haul you off to prison. It is a disgusting abuse of the First Amendment. Thank goodness a jury acquitted him. Now he deserves to be made whole, and I hope that you'll be part of that. I see nobody else here. Are we gonna let it go? Well, they tell me that Senator Cruz is on his way, which means that I can just keep right on questioning. So, what do you think, Mr. Woodward? I'm sure you're really enjoying this line of questioning. Let me ask you something different. Let me ask you about President Trump's executive order on Title IX in men and women's sports. Something you and I talked about is the need to see that the president's executive orders are enforced, that states are complying with them, that they're complying with federal law. Talk to us about the importance of his order protecting women, getting biological men out of women's sports. What does the department need to do there? What do you think is the priority? And tell us why this is so significant.
Thank you for the question, Senator. You know, this is a deeply personal issue to me. I have a 2-year-old daughter who has 3 older brothers. She can hold her own, but it's a problem. It's an issue that has to be addressed. The president has taken this head on as an important issue in his administration. The executive orders speak for themselves. And although I can't comment on pending litigation that has been brought by the Department of Justice, we have seen that the Department of Justice is enforcing the president's executive orders. To quote the president, "We'll see you in court." Don't follow the president's executive order, we'll see you in court.
And you would send that message to universities that are currently failing to comply, that are violating Title IX. I mean, to be clear, Title IX protects women's sports. Title IX creates the right of women to play in sports that have integrity, where they are protected from danger, where they are given the same opportunities as male athletes. These universities that are putting biological men into women's sports and women's locker rooms are flagrantly violating Title IX. So your message to those universities is, if you don't amend your ways, you can expect to face off against the Justice Department in a court of law.
Senator, absolutely. I mean, it's a complicated issue. It's often attempted to make this out as an easy issue, but it is a complicated issue. There are sports for which it is advantageous, right? Men should not be competing in women's gymnastics, for example. And so this is not an issue that is easy to summarize or to make sound bites over. It is complicated, which is why it is important that the Department of Justice is paying careful attention to what the law is and applying the facts to the law.
Mr. Geiser, let me just ask you about nationwide injunctions for a moment and about the proliferation of nationwide injunctions. We have seen them explode. They're first used in the 1960s. Then they're almost never used. Of course, the nationwide injunctions, when you have one individual district court that purports to bind not just the parties before the court, but purports to impose its policy, its ruling, its order on the entire country, including parties not before the court at all, parties well outside the court's geographic jurisdiction or otherwise. Tell us about the importance of reining in the district courts to their proper constitutional role, which does not allow any individual district court to sit in the place of the Supreme Court and make policy for the nation. Tell us about the importance of this.
Well, thank you very much, Senator Hawley. And as you're aware, district courts are charged with adjudicating cases and controversies. And the Supreme Court of the United States has said that that task looks to the relief sought by the parties, and its equitable authority extends to the amount of relief necessary to redress those particular injuries. And as you are also aware, the Supreme Court is currently now considering some litigation involving that, so it would be inappropriate for me to comment on the specifics of that. But I agree with you that Article 3 imposes genuine limits and authorities for district courts, and it's in the text on the judicial power.
Setting aside the litigation currently before the Supreme Court, do you think that it is appropriate and maybe necessary for Congress to use our Article 1 authority to make clear that an individual district court does not have the constitutional authority to bind parties that are not before it or otherwise not within its jurisdiction? I mean, is that something that we Congress ought to consider doing?
Senator, I agree that Congress has an important role in setting the jurisdiction of the inferior courts that Congress creates. Those are the creature of this and the House's work. And so I think this body has an important role to play and could make a significant contribution to justice being done, as opposed to what I think millions of Americans are alarmed to see, which is the weaponization of the entire justice system to oppose the agenda that they enacted by voting for elected representatives like President Trump.
Well, I think we are looking at something that is very much a constitutional crisis, that is a growing crisis, and it is a crisis of district court judges that are way outside the bounds of the Constitution, that are seizing power that absolutely does not belong to them. And you're right, Article 1 does give us the authority to establish those courts in the first instance, to govern those courts. And in this case, I think it's time for this body to take action to ensure that those courts stay within their proper constitutional bounds.
Economic policy. In New York City, the Court of International Trade struck down all of President Trump's tariffs under IEEPA, declaring that they exceeded executive authority. It was not judging, it was judges replacing the president's judgment on declaring a national emergency. And of course, that ruling was almost immediately stayed by the Court of Appeals. Deportation policy. In Baltimore, the chief judge for the District Court of Maryland issued an order preventing the removal of illegal aliens detained anywhere in the country, granting 2 days of automatic protection to anyone who files a habeas petition in Maryland, all without a hearing or legal findings. This single Maryland judge dictated national deportation policy and then tried to claw back the damage by amending the order. As chairman of the Subcommittee on Federal Courts, I'm investigating this overreach, and I've sent a letter to the Judicial Conference of the United States. But the judges did not stop there. In D.C., a judge blocked the federal government from requiring proof of citizenship to vote, overriding election integrity laws across all 50 states. In Boston, a judge weighed in on birthright citizenship, deciding a question of nationwide consequence for millions of illegal aliens, despite the plaintiffs being solely one pregnant mother and 2 nonprofit organizations. That's absurd. That is policymaking and legislating. That is not adjudication. In Boston, a different judge blocked a Department of Energy rate cap, handcuffing efforts to lower taxpayer costs for energy research. In Rhode Island, a judge ordered the federal government to immediately disperse tens of millions of dollars under the Inflation Reduction Act and other programs. The Department of Energy alone was forced to release $50 million by judicial fiat. In San Francisco, a judge mandated that the Office of Personnel Management rehire all terminated federal workers and restricted future firings, effectively turning the judiciary into an HR department. Yet another Maryland judge halted orders intending to stop funding for institutions mutilating minors through so-called gender transitions. These deeply consequential decisions were blocked not by voters, not by Congress, but in each instance by one unelected judge. And it doesn't stop there. Since President Trump returned to office in January, there have been over 40 universal injunctions issued against the federal government. That's in 4 months. 35 of those 40 came from the same 5 judicial districts. Let's put this into context. In the first 150 years of the Republic, 0 nationwide injunctions were issued. 0. That's for 150 years. In the entirety of the 20th century, 27 nationwide injunctions were issued. That's over 100 years. Under Presidents Bush, Obama, and Biden combined, 32 nationwide injunctions. Under President Trump's first term, 4 years, 64 nationwide injunctions, and now in just 4 months, we're already over 40. In 4 months, the Trump administration has seen more nationwide injunctions than the entirety of the 20th century and more nationwide injunctions than Presidents George W. Bush, Barack Obama, and Joe Biden combined. This is not normal. This is not justice. This is an orchestrated campaign of judicial obstruction. Joe Biden, when he was president, nominated to the bench radicals. I have said, only slightly tongue-in-cheek, that Joe Biden did something I used to think was impossible. He made me miss Barack Obama. But by comparison, the Biden judicial nominees were far more extreme and radical than they were under Obama. They sought out radicals who would implement policymaking from the bench, and they are doing precisely that. That is not democracy, and that is not our Constitution. This hearing is to highlight the effects of this judicial tyranny, of single judges deciding they know better when it comes to policy than do the voters of America. We need to defend democracy. And with that, I recognize Senator Whitehouse.
Thank you, Senator Cruz. When I chaired the subcommittee on federal courts, we held hearings on the influence on our judiciary of dark money from the fossil fuel industry and from creepy billionaires. My Republican colleagues weren't interested in helping solve that problem, but those hearings were based on facts. Years of financial disclosures showed a secret billionaire gifts program for amenable Supreme Court justices. Written evidence suggested a justice may have failed to pay taxes on a $270,000 loan that was forgiven, and that false statements were made about a yacht. A mountain of evidence revealed President Trump outsourced to billionaires and their dark money fixer, Leonard Leo, the selection of his judges and Supreme Court justices, which President Trump admitted just last week. Apparently, Leo also, and I'm quoting Trump here, openly brags about controlling the judges his creepy billionaires got appointed. This hearing will be different. A lot of hypocrisy about nationwide injunctions against the Trump administration after Republican colleagues cheered the nationwide injunctions that courts issued against the Biden administration. Indeed, some colleagues filed lawsuits asking for nationwide injunctions against the Biden administration. But now they're shocked that there are nationwide injunctions. Here are some facts everyone should bear in mind during this hearing. Fact number 1. Donald Trump's administration is engaged in unprecedented lawlessness, period. In less than 5 months, President Trump has issued almost as many executive orders as President Biden did during 4 years in office. Many are flat out on their face illegal, as any first-year law student could tell you. Trump tried to end 14th Amendment birthright citizenship. He tried to punish law firms' First Amendment rights to associate with his perceived political enemies. His fossil fuel minion at OMB, Russ Vought, withheld millions of dollars that Congress had appropriated under Article 1. More than 20 years ago, originalist icon Scalia wrote about how illegal that is. The madcap pace and roughshod lawlessness of Trump's executive actions mean district judges across the country are striking them down, not because of judicial obstruction, because he is breaking the law. Hearings like this prop up a narrative that bad courts are stopping dear leader Donald Trump because some cabal of Democratic judges is out to get him. Wrong. The reality is much simpler. He's breaking the law and doing it a lot, and judges are doing their job. It's not just me saying that. Trump-appointed judges from across the country have struck down his illegal actions, holding, for instance, that Trump can't punish the AP for its reporting, that his misuse of the Alien Enemies Act is illegal, and that the administration can't withhold billions of appropriated public health funds. Trump judges, hardly a liberal conspiracy. As it tries to prop up Trump's illegal orders, the MAGA Justice Department is fast destroying its reputation with judges who've said about DOJ arguments, bad faith, shoddy, an admitted lack of any evidence whatsoever, deliberate evasion. Shocking not only to judges, but to the intuitive sense of liberty that Americans far removed from courthouses still hold dear. And the prospect of contempt findings looms. Fact number 2, failing in court, Donald Trump and his allies attack judges and their families. Trump has called judges who ruled against him communists, USA-hating, and monsters. A Republican in Congress put up a wanted poster with judges' faces outside his office. Elon Musk and Laura Loomer have used X to fire up the right wing's flying monkeys about judges, even adding photos of family members in a seemingly coordinated campaign to harass and intimidate. A test is coming of MAGA Attorney General Bondi. Will she let the Marshal Service investigate these threats and their orchestration? There's plenty of predication to look into conspiracy, aiding and abetting, or RICO enterprise liability. Will she let them? Which brings me to fact number 3. In a 6-week period from March through April, 162 judges received threats to themselves or family members of harassment or violence. 162. A pattern was evident. Many had ruled against Trump and then were targeted. The latest tactic is a campaign to send pizzas to judges or family members' homes using the name of the murdered son of a federal judge. It's not clear yet who is behind that campaign, but it's not hard to figure out the message. Stop ruling against Trump or else. These attacks have gotten so bad that the Chief Justice issued a statement, and the Judicial Conference formed a Judicial Security and Independence Task Force. Now I'd like to see some sign that the threats are being duly investigated. To the extent that this hearing encourages that animus further, it is deeply regrettable.
I thank Senator Whitehouse and now recognize Chairman Schmidt.
Thank you. Thank you, Senator Cruz. As chairman of the Subcommittee on the Constitution, I'm glad that we've convened this hearing. Universal injunctions effectively didn't happen for the first 200 years of our Constitution. Yet they become a fixture in our legal system in the last 20, especially when Donald Trump occupies the White House. The courts can play an important role in reining in an executive branch that's out of control. This is especially important when reining in actions by unelected, unaccountable bureaucrats who act outside of the scope of their congressionally authorized authority. But what happens when Article 3 has no limits? As listed in the hearing's title, Alexander Hamilton called the judiciary the least dangerous branch in Federalist 78. And historically, in Federalist 78, Historic was responding to the anti-federalist Brutus, who was raising the alarm bell over the seemingly unchecked power of Article 3 to subvert the will of the people and the rights of citizens. Hamilton responded that judges will be forced to behave because nothing guarantees that their orders are enacted. Judges can't raise an army. They can't collect taxes or duties. As Hamilton said, the judiciary must ultimately depend on the aid of the executive branch to enforce its judgments. To date, the Trump administration has followed every court order, enforced every judgment. It's no one's desire to put Hamilton's theory into practice. That is why this hearing is so important. We are not a juristocracy. We do not want the judiciary to subjugate itself. We want to keep it from subjugating others. I agree with Hamilton that there is no liberty if the power of judging is not separated from the legislative and executive powers. But this runs both ways. There can be no democratic accountability, no Republican government with an overly activist judiciary that allows over 600 judges to wield limitless power. On one particularly troubling example, district court judges have not been assigned cases randomly or transparently. In March, Chief Justice Boasberg, right here in D.C., has found himself into 4 major Trump cases, a statistical impossibility. Boasberg took over the Alien Enemies Act and ordered planes to be turned around in the dead of night, despite not being the emergency judge on duty that night. It seems clear that as chief judge, he has play and he wants to be able to grab cases for himself. I've had firsthand experience with this non-random case assignment in our federal appellate court system. When I was Attorney General of Missouri, I often found myself litigating in the 8th Circuit, a circuit of unique makeup. Of the 11 judges in the circuit, 10 have been appointed by Republicans. Yet, the one Democrat appointee, Judge Jane Kelly, found herself hearing nearly every political sensitive case in the circuit. Time after time, case after case, miracle after miracle, for the Democrats, Judge Kelly would be there for nearly every politically sensitive case. This was not due to the good luck of Judge Kelly. The circuit clerk's office, which assigned cases to appellate panels, was filled with her former clerks and ideological compatriots. In practice, they set the nationwide policy by rigging case assignment. Another issue is the universal injunction is a judicially created remedy while Congress set up a procedure for group relief under Rule 23. As Solicitor General John Sauer recently argued compellingly, the proper avenue for group relief is under Rule 23 class actions. Rule 23 was designed to ensure a structured and fair approach to broad legal challenges. I'm hopeful that the Supreme Court will curb injunctions to restore proper judicial limits and respect the separation of powers. A district judge blocking deportations is as absurd as directing military strategy. This is activism, not judgment, not the rule of law, and it undermines the voters' mandate to secure our borders. Enough is enough. We must act here in the Senate to fix these issues. Article 1 isn't alone in this. The Judicial Conference and the Supreme Court must get their houses in order as well. Does our Constitution establish a judiciary that resolves cases or sets policy? In this committee, do we confirm judges to take the bench or to take the podium? The founders clearly intended the former. It's time for a reset. The American people elected President Trump to secure our border and restore our nation. I look forward to the testimony of the professors, and I urge this committee to advance reforms that uphold the separation of powers.
Thank you. I now recognize Ranking Member Welch.
Thank you very much. You know, the concrete issues of a universal injunction or forum shopping are things that we can address. But there is a context that we're all operating in, and this is where I disagree with my colleagues, particularly Senator Cruz and his recitation of what he saw as a judicial rampage. This moment we're in our country is testing whether the separation of powers, 3 co-equal branches of government, shall endure. That's really the question. We've seen an abdication of constitutional responsibility by the Congress. It's appalling. Ceding to a president the ability to impound funds, something was declared unconstitutional in the Nixon Doctrine. Ceding to the president tariff authority, which in the Constitution belongs to the policymakers in Congress. Just two examples of Congress ceding its constitutional authority. That's done willingly by my colleagues in the House and some in the Senate. We should reassert our authority. But the second leg of that, the transfer of authority to the executive, is the rampant attack on the judiciary. And Senator Cruz gave some examples of what he thought was judicial overreach. Each one of those examples, as I see it, was the judges doing their job. They disagreed. And when they disagreed, it was asserted by the president and by the attorney general that they were monsters, they were renegades, they were out of control. It was an ad hominem attack because judges were doing their jobs. And I will say we can deal with the forum shopping, which is something the private bar gets involved in. We can deal with universal injunctions. But the all-out assault on judges, because they make decisions, which is the job it is they have to do. And the decision is, has a president exceeded his authority? The decision is, has the Congress passed a law that deviates from constitutional requirements? Those are so profoundly important to keep that separation of powers and to keep the competition between the three branches so that we don't have absolute power vested in a single person, and that's the chief executive. So when, Senator Cruz, you talk about a judge making this decision about keeping somebody here, it's called due process. I'm for due process. When we talk about judges striking down under the international trade agreement, whether the president has authority to set these tariffs, and it's a three-judge decision, one appointed by Trump, one appointed by Obama, one appointed by Reagan, and they say the president didn't have authority, I would say that is the judges doing their jobs. But what is most profoundly important for the well-being of our country is that the Congress reassert its authority to pass laws, to restrict the executive or to empower the executive, but not to cede our authority to the executive ever. And it's our responsibility to do every single thing we can to validate the legitimate exercise of the decision-making authority of the judiciary. I look forward to this hearing and the testimony of the witnesses. Thank you.
Thank you. I would make two brief observations. Number one, it is interesting as our Democrat colleagues defend these nationwide injunctions that neither of them made any reference to the fact that the number of nationwide injunctions issued in the first 4 months is greater than the entire 20th century and is greater than all of the nationwide injunctions issued against Bush, Obama, and Biden combined, nor did they address the disturbing fact that of the 40 universal injunctions that have been issued in the last 4 months, 35 of them came from the same 5 judicial districts. There is a reason for this. Blue state attorneys general and radical leftist groups are seeking out affirmatively radical judges who they know will impose their own policy preferences. If it were simply, as our Democrat colleagues said, judges following the law, then you wouldn't have to keep going to the same radical judges over and over and over again, because judges across the board should do that. But the litigants know exactly who the zealots are that are on the bench, and that's who they are seeking out. I will also point out that the discussion about the urgency of protecting the safety of judges. Listen, I agree. We should protect the safety of every federal judge, but it is interesting because my Democrat colleagues were utterly silent during 4 years of the Biden administration when you had violent mobs outside the homes of Supreme Court justices unhappy with the Supreme Court's ruling in Dobbs, and the Biden Justice Department refused to enforce federal law and protect the justices. And my Democrat colleagues were perfectly happy with Supreme Court justices being threatened if they disliked the rulings that were coming from the Supreme Court justices. Unlike my colleagues, I believe we should protect judges regardless of whether I agree with them or not. We should protect their safety. And every time you hear a Democrat senator talk about protecting judges from acts of violence, you ought to ask them, why did they not have a word to say about the Biden Justice Department allowing mobs to threaten the families and children of Supreme Court justices night after night after night, while Biden's Attorney General refused to follow the law? And with that, I'll recognize the ranking member of the full committee, Senator Durbin.
Thank you, Senator Cruz. They asked Winston Churchill after World War II how he thought history would treat him and his conduct of the war. He said, "I'm not worried about it because I plan on writing that history," which he did. Today we see an example of written history, revisionist history, from the chairman with the statement that he just made about concern over the safety of federal judges. I cannot remember a single instance of what he just described, not one, when there were protests and demonstrations before the homes of judges, regardless of who appointed them, Republican or Democrat. Our feeling was they're all entitled to a guarantee of safety to the best of our ability. And that's what I did as chairman of this committee, and I hope that I believe I spoke for the Democrats in that approach. The title of this hearing says a lot. In full, the supposedly least dangerous branch, District Judge versus Trump. The idea being pushed by my Republican colleagues is not only that judicial branch and district judges are dangerous, but they are dangerous for the plain and simple reason that some judges have had the audacity to rule against President Trump. When the chairman from Texas starts talking about the number of times there have been ruling by the court, I have 3 words for him: flood the zone. Flood the zone. When Steve Bannon was asked, what's the policy, what's the strategy of the new Trump administration, we're going to flood the zone, and they did. More executive orders issued by this president in the beginning of his presidency than any president in history, leading to more court challenges than any president in history. It seems pretty logical to me. By framing the hearing as they have, my Republican colleagues have shown their hand. This hearing is not really about policy or legal issues. Instead, it's about challenging the authority and legitimacy of the judiciary. They are showing their undying loyalty to their leader, the president. This hearing is merely the latest episode in an ongoing effort by President Trump and his allies to undermine the judiciary and intimidate judges who dare to rule against them. In March, the president demanded the impeachment of a federal judge simply because he ruled against his administration, calling him, quote, and I quote, I want you to hear these words, a radical left lunatic, a troublemaker and agitator. In May, President Trump referred to judges who ruled against his administration as, quote, communist radical left judges. 2 days ago, the president posted in the quote, if the courts somehow rule against us on tariffs, which is not expected, that would allow other countries to hold our nation hostage with their anti-American tariffs that they would use against us. That would mean the economic ruination of the United States of America, end of quote. These statements that I've just read are not normal. It is difficult to imagine either President Bush, President Obama, or President Biden using such unhinged, bombastic, and childish language, or calling for the impeachment of a judge simply because that judge ruled against his administration. The reason it's difficult is because Obama, Biden never did anything like this. But imagine if they had, and how congressional Republicans would have responded. They would have shouted about it from the rooftops, posted furiously on social media, and the only person they would have considered impeaching would have been the president himself. But because this president is a Republican, because the president and his allies go after anyone who dares to speak up, because fear of political retribution is now at the core of this MAGA world, my Republican colleagues have been silent as the president has made the statements he has about judges. Instead of rushing to defend the judiciary and our system of government, they are rushing to defend the president. While my colleagues on the other side may try to make it appear as though decisions of district courts against the president are somehow dangerous, In reality, it's the attacks on the judiciary itself that are dangerous, to both the rule of law and to the actual judges themselves. I could go through chapter and verse of federal judges who have been intimidated physically. In fact, deaths that occurred in the Northern District of Illinois. One of my judges, she's now retired, lost her husband and her mother to a litigant who attacked her at her home. It's serious. I don't think it's a mere coincidence this spike in violence against judges coincided with increasingly harsh rhetoric against the same judges and the president's personal call for the impeachment of a federal judge on March 18th. Some judges and family members have received threats in the form of hundreds of anonymous pizza deliveries to their home. Pizza deliveries? These deliveries are an effort to demonstrate that those seeking to intimidate a targeted judge know exactly where those judges live. Nearly a month ago, I sent a letter to the Attorney General Bondi and FBI Director Patel, asking them to investigate this effort with the pizza deliveries and other threats against federal judges, and to provide information on steps they're taking to protect those judges and their families. I did not designate just Democratic appointed judges or Republican appointed judges, but all judges. Showing the priorities of this administration, I'm sorry to say, I have yet to receive a response from either the Attorney General or the Director of the FBI. In the meantime, I ask my Republican colleagues to join me. Let us recognize that violence begets violence. Threats of violence, whether from the right or left of the political spectrum, are never, never acceptable. People are welcome to debate the merits of any particular judicial decision, but we cannot condone personal attacks and threats against judges who rule against this administration. And we can't allow partisan politics or the latest outrage from the president to undermine the judicial branch and our constitutional order. I yield.
Mr. Chairman, would you indulge me for a moment?
We indulge you every moment.
I appreciate that act of generosity. It's just something you said that I think is actually dangerous and should be addressed, and you're welcome. But when Judge Anderol was killed in New Jersey, the Republican colleagues in the Senate, their outpouring of support, their outpouring of concern, they're willing to work together on a bipartisan bill was extraordinary. It shows the truth of this institution that despite some of the fiery rhetoric that you were sowing, we're really a bipartisan, working bipartisanship. Cornyn and Coons, after the incidents you're talking about, got together and actually passed a bill to better protect our Supreme Court justices, many of whom are friends of ours. You know, Gorsuch and I disagree on a lot of stuff. I knew his wife before he did. We studied together at Oxford. This implication that there was silence when there were threats on their people's houses is absolutely absurd. I remember the rhetoric and the comments, the concern from Coons. I actually distinctly remember you, Chairman, on more than once condemning those attacks on Republican-appointed jurists. To say things like that feeds just the partisanship in this institution and feeds the fiery rhetoric. And it's just plain not true. It's just plain not true. And I think you know that, but we can pull from the record from my colleagues in real time, literally days afterwards, condemning it. There's a lot of substantive things to say here, but to think that the lack of humanity when people's homes are being threatened was not in existence, I think that's unfair and really concerns me that you would say that in the way that you did.
Well, I thank my colleague from New Jersey. I will note, as John Adams observed, that facts are stubborn things. And it is existing federal law, 18 U.S.C. section 1507, that makes it a crime to protest at a judge's home. And the law provides whoever with the intent of interfering with, obstructing, or impeding the administration of justice, or with the intent or of influencing any judge, juror, witness, or court officer in the discharge of his duty, pickets or parades in or near a building housing a court of the United States, in or near a building or residence occupied or used by such judge, juror, witness, or court officer, or with such intent uses any sound truck or similar device, or resorts to any other demonstration in or near any such building or residence, shall be fined under this title or imprisoned not more than 1 year, or both. That is federal criminal law. Night after night after night, angry mobs were outside the Supreme Court justices' homes, And in the entire course of it, the Biden Justice Department prosecuted nobody. We had the Attorney General sitting at that table, and multiple Republican senators asked him, why are you not enforcing the law? What they are doing is a crime. And my friend from New Jersey said, it is a lie to say we, the Democrats, condone this. I would challenge, my friend, find a single Democrat senator on this committee holding the Attorney General to account for not enforcing this law. I was here at those hearings, and I do not recall a single Democrat senator saying to the Attorney General, you should arrest these people who are violating the law. You should protect the judges. I agree that there was general language against violence, but not a single Democrat senator that I ever saw in this committee was willing to hold Attorney General Merrick Garland to account for flagrantly disregarding the federal criminal law because the Biden administration agreed with the protesters and I think wanted those justices harassed at their home.
I really appreciate that you've now shifted the accusation you made earlier. Your accusation was that we were silent in the face of protests at Supreme Court justices' homes. Again, we joined together in a bipartisan way, not only to condemn that, but to pass legislation to extend round-the-clock security protection, literally days. It was introduced May 5th, passed the Senate in a bipartisan fashion on May 9th. So if you're saying that we didn't criticize
Merrick Garland, did the Biden DOJ arrest a single person under this law?
You are now changing the
No, that is what I said. That is what I said.
Again, I'll pull the record.
Did the Biden DOJ arrest even one?
Again.
The answer is no.
My point to you is the accusation that the Democrats on this committee do not care about the safety of federal judges. I did not interrupt you, sir. I would appreciate if you let me finish. I am sick and tired of hearing the kind of heated partisan rhetoric, which is one of the reasons why we have such divisions in this country. The attacks we see from the President of the United States of America trolling and dragging judges through is what we should be talking about that puts people in danger. I'm simply taking issue with the claim that you made at the top that people on the Democratic side of the aisle do not care about the safety and the security of judges and said nothing. You said we were silent after people's houses were protested. That is a patent lie, sir. We were not silent. We took action. We joined in a bipartisan way to protect those judges, as was done in a bipartisan way to protect a New Jersey judge after their horrific attack at their home. So I see you now trying to shift the debate to whether we talk to an attorney general. I'm simply taking issue with this accusation that somehow we Democrats are so bad because we don't call out threats to our to our judicial colleagues. And that is wrong. You could change the argument now that you want, but what you said was patently not true and was in fact a patent lie.
So I do enjoy the fact that my colleague from New Jersey raises his voice and says it's a patent lie and says he's doing so in defense of lowering the rhetoric. There is some irony to doing those two together. I'll point out that in the entire course of those remarks, Senator Booker did not dispute the central point I made, which is the Biden Justice Department arrested 0 people, prosecuted 0 people for violating the criminal law, and every Democrat senator on this committee was silent about it. And this was an ongoing pattern for months. And I would note also that the senator from New Jersey clutched his pearls about language threatening judges, and yet I do not recall a single Democrat senator of this committee saying a word when Chuck Schumer went to the steps of the Supreme Court and threatened the safety of the Supreme Court justices by name, Gorsuch and Kavanaugh, and he said, you have unleashed the whirlwind and you will pay the price. And not a single Democrat senator had a word to say about this. And so their outrage is selective. And I will give my colleague from New Jersey a chance to just answer a simple yes-no question. Should the Biden Justice Department have enforced the criminal law against protesting at a justice's home? Yes or no?
So the rank hypocrisy of Chuck Schumer apologizing the next day and you holding that standard for him and not for your president, who you actually rightfully described when you were running against him in a primary. I would love to run those tapes of how you perfectly talked about the danger of our president and his rhetoric. But now you are failing, in fact, blind to the very things you're accusing Chuck Schumer of. I don't think Donald Trump would know an apology if it hit him in the head. Never has said apologizing. So again, you are very, very, sir, very, very deep into the waters of hypocrisy in your criticisms of Chuck Schumer.
So let the record reflect that Spartacus did not answer the question and did not tell us whether the criminal law should be enforced, because he knows the answer is yes. And he knows that the Biden Department of Justice was being wildly political and partisan in refusing to enforce the law because they disagreed with the Supreme Court justices' rulings. I have also, in addition to Senator Durbin, who's given his opening statement, I have a written opening statement from Chairman Grassley. Without objection, that written statement is entered into the record. And I will now briefly introduce our distinguished witnesses. We have three. Our first witness is Professor Josh Blackman, who holds the Centennial Chair of Constitutional Law at South Texas College of Law in my hometown of Houston, Texas, where he's been teaching since 2012. And although Professor Blackman was born and grew up in Staten Island, he got to Texas as fast as he could. And both of his daughters are proud native-born Texans, and I commend you for that. He is one of the country's leading voices on constitutional law. He has testified before Congress. He is a frequent voice in the New York Times, the Wall Street Journal, the Washington Post. He is, in 2024, was named the Jurist of the Year from the Texas Review of Law and Politics, an award that is near and dear to my heart, since in a previous year I received the same award. And he is a senior editor of the Heritage Guide to the Constitution, 3rd edition. And he's authored 3 books, including An Introduction to Constitutional Law, which became a top 5 bestseller on Amazon. Our second witness is Professor Kate Shaw. Professor Shaw is a constitutional law scholar and professor of law at the University of Pennsylvania Carey School of Law. She joined the Penn Carey Law faculty in January 2024 from the Benjamin N. Cardozo School of Law, where she also served as co-director of the Florsheim Center for Constitutional Democracy. Her scholarship focuses on executive power, the law of democracy, the Supreme Court, and reproductive rights. She has also taught courses on administrative law and legislation, as well as a seminar on the U.S. Supreme Court. Before entering the academia, Professor Shaw served in the Obama White House counsel's office and clerked for U.S. Supreme Court Justice John Paul Stevens and Judge Richard Posner of the U.S. Court of Appeals for the 7th Circuit. Her academic writing has appeared in the Harvard Law Review, Columbia Law Review, Georgetown Law Journal, and other journals. She is married to Chris Hayes, a political commentator and host on MSNBC. And our third witness, Chairman Schmidt, will introduce, and if you can start the testimony, I've got to run to the floor and vote, and then I'll be back.
Okay. The third witness is Joel Alisea, and he's the inaugural St. Robert Bellarmine Professor of Law and Director of the Law School Center for the Constitution and the Catholic Intellectual Tradition. He has also served as a visiting professor at Duke Law School and Notre Dame Law School. Prior to joining the Catholic Law faculty, Professor Alisea practiced law for several years at the law firm of Cooper & Kirk, where he specialized in constitutional litigation. He previously served as a law clerk for Justice Samuel Alito on the U.S. Supreme Court and for Judge Dyermood and Judge O'Scanlan on the United States Court of Appeals for the 9th Circuit. Professor Alisea's scholarship has focused on constitutional theory, civil procedure, and constitutional law. He has been involved in the ongoing discussion on nationwide injunctions in the scope of the judicial power, both in the academy and in working with the Trump administration. And at this point, before you guys give your opening statements, it's a tradition of this committee to be sworn in. So if you'd please stand and raise your right hand. Do you swear that the testimony you're about to give to this committee is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Professor Blackman, we'll start with you.
Thank you. Chairman Cruz, Chairman Schmidt, Ranking Member Whitehouse, Ranking Member Welch, thank you so much for inviting me to testify. My name is Josh Blackman, and I'm the Centennial Chair of Constitutional Law at the South Texas College of Law, Houston. The topic of today's hearing is very timely. The supposedly least dangerous branch, district judges versus Trump. It is often repeated that we have three co-equal branches of government, but this isn't true. In Federal 78, Hamilton described the judiciary as the least dangerous branch. Unlike Congress, which is a power of the purse, and the president has the power of the sword, the courts have mere judgment. Yet it has been deeply ingrained in our consciousness that the court's foundational role is to balance the powers of the elected branches. Indeed, Chief Justice Roberts recently boasted that the courts check the excesses of Congress and the executive. But the Chief Justice is incorrect. Indeed, Vice President Vance recently explained that Roberts expressed a profoundly wrong sentiment. Or more local to me, Judge Ho in Houston aptly observed, it is not the role of the judiciary to check the excesses of the other branches any more than it's the judiciary's role to check the excesses of any other American citizen. So the question is, who will check the excesses of the executive? At least with regard to the lower courts, you all, Congress. The Constitution refers to the federal district courts as inferior courts. Yet far too many lower court judges seem to have a superiority complex. We're witnessing a never-ending onslaught of universal injunctions that make it nearly impossible for the executive branch to function. So what can be done? We can't look to the courts to check themselves. The long history of judicial supremacy teaches that judges of all stripes, conservative and progressive, seek to defend and entrench their own institution. The answer to any sustainable reform must come from the legislature. To paraphrase Madison in Federalist 51, legislative ambition must counteract judicial ambition. Yet regrettably, most debates about judicial reform get bogged down in politics. When there's a Republican president, Democrats love the universal injunction. When there's a Democratic president, Republicans love the universal injunction. It's predictable. Proposals that help only one side of the aisle have a slim chance of enactment. The federal courts cannot be reformed through unilateral disarmament. Any reform must be bilateral. I published an article called Bilateral Judicial Reform in the Texas A&M Journal of Law and Civil Governance. This was in 2024, before the election. And I got 10 ideas to fix the courts that might appeal to people on both sides of this aisle. I will talk about 3 of them in my limited time today. Number 1, cases seeking a temporary restraining order can be decided by a single judge, but can only give relief to the named parties and are limited to 7 days. No longer can a single judge issue universal TRO that lasts for nearly a month without any appellate review. Second, cases seeking preliminary injunction or equivalent relief against the federal government and state governments are referred to the en banc court, which appoints a randomly drawn 3-judge panel with 2 circuit judges and 1 district court judge. There's some value in having a multi-member body consider an issue rather than a lone district court judge deciding difficult questions. And rather than having 2 district and 1 circuit, I prefer 2 circuit, 1 district, because these cases tend to focus more on law than on facts. The third proposal focuses on the appellate process. Chief Justice Roberts recently stated that the appropriate response to disagreement with the judge is the normal, he said, the normal appellate review process. As things stand now, the Supreme Court has a completely unpredictable and indeed arbitrary approach to emergency applications. I think we maybe all agree upon that. Congress can make the appellate review process of the Supreme Court normal again. Under my proposal, injunctions of statutes against federal government and state governments are automatically stayed. The stay is automatic, it's not discretionary. And if a 3-judge panel submits what I call a certificate of division, that is, 2 judges go one way, the other judges go the other way, the case is appealed to the Supreme Court's mandatory jurisdiction. They can't deny cert. And oral argument is decided on an emergency docket timeline, which Congress would then set. I think these 3 measures would have bipartisan appeal, which I hope they do, and will go a long way to addressing the never-ending fights between the president and the judiciary. Thank you so much, and I welcome all of your questions.
Thank you. Professor Shaw.
Good afternoon, chairs, ranking members, distinguished members of the subcommittees. Thank you for the invitation to testify today. I understand that the purpose of today's hearing is to discuss recent judicial rulings against the Trump administration and to situate those rulings in historical and institutional context. There is no question that the Trump administration has been on a losing streak in federal court. According to the most recent data compiled by Professor Steve Vladek, district courts have ruled against the administration in 97 cases to date. That is a large number. but it is a number that is best understood in context. First, it has to be viewed in the context of the unprecedented volume of executive action we have seen from this administration. As of May 24th, the second Trump administration had issued 157 executive orders. By comparison, the Biden administration issued 162, nearly the same number, over the course of 4 years. The first Trump administration issued 220 over 4 years. It is not surprising that this much more executive action than previous administrations has drawn more challenges. The second thing to understand is that these rulings have come from judges who sit in district courts across the country and who were appointed by presidents of both parties. 25 district courts in 10 circuits and 73 judges appointed by 7 presidents have ruled against this administration. That leads me to my third point. These are not about policy disagreements. The reason there has been such wide and cross-ideological consensus over the impermissibility of the administration's actions is because the actions have been plainly unlawful, and that has been clear to jurists of all stripes. Again and again, the administration has acted in violation of both the constitutionally required process for lawmaking, one that gives Congress primacy, and the rights the Constitution commands government to respect. To be sure, some of these preliminary rulings against the government will be, and some have been, reversed or stayed on appeal. But it is telling that there are so many lower court losses that the administration has not even bothered to challenge. That is true in the birthright citizenship case currently pending in the Supreme Court, in which the lower courts have unanimously ruled against the administration. But the administration has not challenged those rulings on the merits. Instead, it has asked the court to use the case as an opportunity to restrict lower courts' ability to provide nationwide relief, and to do that in a context in which the administration is not even defending the lawfulness of its own executive order. Rather than focus on the appellate process or on remedying the legal defects that have been revealed by litigation, this administration and many supporters have suggested that the problem is district judges. The separation of powers is dynamic, it is not static, and there is definitely room for debate about the proper scope of both presidential and judicial power. At different moments in our history, different institutions and actors have sought to significantly increase their authority, sometimes in ways that could not be squared with the basic design of a constitution committed to limits on any single entity's power. At this moment, the entity engaging in overreach is the executive branch. This administration has been marked by a breathtaking degree of presidential unilateralism that is flatly inconsistent with statutes, the Constitution, and over 2 centuries of practice. For that reason, it would be profoundly misguided to seek now to curtail courts' authority by eliminating or seriously limiting their ability to issue nationwide injunctions. It is true that the use of such injunctions has increased in recent decades, and it is true that injunctions can be abused. But at this moment, courts are the only branch of government doing meaningful work to check the executive, protecting basic constitutional values, congressional prerogatives, and our liberty, which the separation of powers is designed to safeguard. If Congress does wish to wade into defending the separation of powers, I would suggest a couple of options. First, it could give the president some of the authorities he has tried to assert. If Congress agrees that the federal government should not protect Americans from abusive financial products and services, it can pass legislation doing away with the Consumer Financial Protection Bureau. If it wants to give DOJ access to Americans' sensitive personal information, it can repeal or amend the Privacy Act. If it wants the president to be able to impose sweeping tariffs based on his determinations of trade deficits, it can grant that statutory authority. As far as I know, it hasn't done any of that. Second, it could turn its attention to judicial security. Threats to the physical safety of federal judges have spiked in the last 4 months, and so have threats to judicial independence. There's a pending proposal that would move the U.S. Marshal Service from the executive branch to the judiciary in order to ensure that marshals are able to focus effectively on protecting federal judges and executing federal court orders. That would both comport with the original structure of the Marshal Service and would align the security practices of the judicial branch with those of Congress, right? Each branch protected by its own security apparatus, not subject to direct control by another branch. The federal courts are an important part of our constitutional scheme, and at their best, they can serve both to make rights meaningful and to enforce and facilitate core commitments to popular sovereignty and self-rule. They have not always done that, and again, a healthy democracy allows debates about the proper scope of judicial authority. But many attacks critiques on the judiciary do not appear to be animated by a desire for good faith debates about the limits of constitutional authority. They seem instead of a piece with other efforts to neutralize any actor or institution that would seek to limit this president's power. Thank you again for the opportunity to testify, and I look forward to your questions.
Thank you, Professor Shaw. Professor Alicea.
Mr. Chairman, Ranking Member, members of the subcommittee, thank you for the invitation to testify today. It's an honor to speak with you. While the topic of today's hearing touches on many issues, my understanding is that I've been invited to address the practice of universal injunctions in particular, and that will be the focus of my testimony. An injunction is an order from a court directing an entity like a government official or a government agency to do something or refrain from doing something. Courts have been issuing injunctions for centuries, and when injunctions only grant relief to a party to the case, they're generally not controversial. What makes universal injunctions controversial is that they purport to give relief to entities that were never made parties to the case. In the birthright citizenship cases now before the court, for example, a district court judge in Seattle issued an injunction forbidding the enforcement or implementation of the president's executive order on a nationwide basis. That means that the executive order cannot be enforced against anyone, even though the only parties challenging the order were 4 states and 2 individuals. Now, universal injunctions are damaging to our political and legal system for many reasons. The effect of a universal injunction is that the policies of the elected president are subject to what is effectively a veto by unelected district court judges. Because it only takes a single judge to issue a universal injunction, the president's opponents only have to win 1 lawsuit to stop the president, whereas the president has to win every single lawsuit if he wants to implement his challenged policies. Because they place unelected district court judges in charge of national policy, universal injunctions are a problem for presidents of both parties. This is not a partisan issue. But universal injunctions have been used at an astonishing rate against President Trump in particular, which is why the issue has become so prominent over the last few months. For example, during the month of February alone, more universal injunctions were issued against President Trump's policies than in the first 3 years of the Biden administration. The result has been an atmosphere of continuous emergency throughout the first few months of President Trump's second term. It seems as if every time the president issues a new policy, it is almost immediately followed by a district court issuing a universal injunction. Since the president cannot allow a single judge to dictate national policy, the administration has had to seek emergency intervention by a court of appeals. And whichever party loses in the court of appeals then seeks emergency intervention by the Supreme Court. The court has therefore been inundated with almost non-stop emergency litigation, partly because of the practice of universal injunctions. The seemingly unending stream of emergency petitions has forced the court to make quick decisions on controversial and contested legal questions, often without the benefit of oral argument, adequate briefing, or different views expressed by the lower courts. This is not how our constitutional system was designed to work. Article 3, Section 1 of the Constitution vests the judicial power of the United States in the federal courts. As understood at the founding, the core meaning of the judicial power was the authority to resolve disputes between parties according to law. This party-centric understanding of judicial power explains why Article 3, Section 2 of the Constitution extends the judicial power only to cases or controversies, that is, disputes between parties. And that's why the Supreme Court has repeatedly held that parties do not have standing to seek relief beyond what is necessary to remedy the alleged harm to the plaintiff. Prior to 1789, injunctions were understood to be limited. An injunction could only provide whatever relief was necessary to redress a plaintiff's asserted injury. The same understanding of injunctions prevailed until the mid-20th century. Universal injunctions, it bears emphasizing, are a 20th century development, and their routine use against government action only began within the last decade. Thus, federal courts lack the power to grant equitable remedies that extend beyond what is necessary to redress the plaintiff's alleged harm, which is precisely what universal injunctions purport to do. The American people never gave judges the power to issue universal injunctions. Judges have seized that power for themselves, and only quite recently in our history. District court judges are thus exercising power for which they have no constitutional warrant. While universal injunctions have damaged the presidency and the Supreme Court, they have done the most damage to democratic governance by illegitimately thwarting the will of the people's elected representatives. As Justice Elena Kagan once observed, quote, "It just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through the normal process," unquote. Courts play a vital role in our constitutional system. They resolve disputes between parties according to law. And in the process of doing so, they say what the law is, as Chief Justice John Marshall said in Marbury versus Madison. None of that is at issue in the controversy over universal injunctions. What is at issue is whether courts can step beyond their limited role of resolving legal disagreements between parties and instead resolve policy disagreements for the whole nation. The answer to that question should be obvious: no.
Thank you to each of the witnesses for your testimony. Professor Blackman, prior to 1963, had any federal court issued a nationwide injunction blocking federal law or executive policy?
I'm not aware of any.
Would you agree that from the founding through the 20th century, the federal judiciary consistently understood its powers to be limited to the parties before the court?
Yes.
And would you agree that the widespread use of universal or nationwide injunctions, especially against presidential actions, is a recent development emerging in the last decade?
Yes.
That's important history, because what we're seeing now is not normal. And we have over 2 centuries of history when this didn't happen. It is instead a novel and dangerous concentration of judicial power. When a single district judge issues a nationwide injunction, are they acting as a constitutional judge or as a de facto national policymaker?
It's effectively a veto in the executive branch.
We've seen district judges block President Trump's policies on immigration, energy, birthright citizenship, and even federal hiring and firing, all prior to any appellate review. All without any input from Congress, all from one single judge. Let me offer an analogy. Suppose the federal government approves a plan to cut down trees in a national forest to make way for a pipeline. One person who occasionally camps in that forest files a lawsuit. The judge not only grants relief to that individual, but certifies a putative class action on behalf of all campers nationwide and issues an order blocking any tree cutting in any forest used by any member of the putative class across all 50 states. Professor Blackman, is that consistent with the Constitution's design for judicial relief?
No, it is not.
Or is that rather a recipe for nationwide paralysis based on a single courtroom?
Yes.
Would you also agree that the proper constitutional remedy is to address the plaintiff's actual injury, not to give one judge the power to halt activity unrelated to the case at hand?
Article 3 requires that.
And how does Article 3 require that?
Article 3 speaks of cases and controversies. As specific people have specific injuries. You cannot grant relief to broad classes doing a certain injury before the court.
And if broader relief is truly necessary, wouldn't that be better handled by class certification, by the appellate courts, or by Congress, not a lone district judge rewriting national policy?
Absolutely.
Can you explain how this pattern of nationwide relief not only intrudes on the president's Article 2 powers, but also undermines Congress's own lawmaking authority?
What ends up happening is you file many lawsuits in many districts seeking parallel relief. And it only takes one judge to grant the universal injunction. And once the judge grants the injunction, it's off to the races. Unless ruling stayed, the executive branch must immediately halt what it's doing. And this has really changed the way the executive branch and the courts have operated, as you said, over the past decade. And I think this time is ripe to actually address this issue and figure a way to stop this sort of insanity. We can't leave it to the Supreme Court to figure everything out.
And Professor Blackman, your testimony outlines structural reforms that Congress could enact to restore balance. Can you explain how requiring a 3-judge panel drawn from both district and circuit judges would deter judicial overreach and restore legitimacy to preliminary relief?
Well, this is how Congress ran things for much of the 20th century. They stopped in the 60s and 70s. The benefit of a 3-judge panel is you have diverse voices. In fact, even on this dais, you don't always agree with each other. But when you talk to each other, you find perhaps the closer truth. A single judge acting by himself or herself can often be like a god. There's no limitation of what they can do. But the benefit is if you have 2 circuit and 1 district, you're basically bypassing this next layer of review. Have the initial panel, 3 judges, and have managed review by the Supreme Court. To cut out this race to the Court of Appeals, this race to the Supreme Court, let's compress the process and get to the result quickly enough so these issues of national significance are resolved fairly.
And by the way, if the characterization of these nationwide injunctions by my Democrat colleagues was accurate, if this was simply a result of, in their view, Trump's repeated lawless activities, one would assume a 3-judge panel would find the same ruling on the merits as a particular lone district judge. Is that correct?
In theory, but if drawn randomly, I think it's less likely. Random draws of 3-judge panels would be a very good change to see how things would work out.
Well, and much like Sherlock Holmes and the lesson he derived from the dog that did not bark, in this case, when we hear our Democrat colleagues talking about this is simply enforcing the law, the dog that isn't barking is why do they keep going to the same handful of radical judges in bright blue districts? And why will every Democrat on this panel oppose any effort to require a 3-judge panel for a nationwide injunction? And the answer is they know fully well that a fair panel would reject the vast majority of these claims. And at the end of the day, I think too many Democrat members of this body want to frustrate the will of the voters who reelected President Trump and elected a Republican Senate and a Republican House, and they're perfectly happy for lone judges to impose their own policy preferences rather than respect the democratic will of the voters. Senator Whitehouse.
Thank you. It strikes me that what we have here is a team that has taken the field and engaged in unprecedented numbers of fouls and unprecedentedly flagrant fouls. And when the refs blow the whistle on the unprecedented number of fouls, the partisans of the team committing the fouls call out the referees for the unprecedented number of whistles that they blow. To try to level set this, let me ask if you can do a yes or no answer. Let's try to go right down the panel, yes or no. Is it appropriate to call judges USA-hating monsters who want our country to go to hell?
No.
No.
No, Senator.
In general, no, Senator.
And is it appropriate to call judges lunatics who do not care even a little bit and could very well lead to the destruction of our country?
I don't think so.
No.
No.
And is it appropriate to post pictures of judges' children with the intent to incite harassment and threats?
No.
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 Okay, good. We're off to a level set. I'll take that. Professor Alessia, when you were installed in your chair, the announcement was that the chair was made possible through the generosity of Leonard Leo, trustee of both the Marble Freedom Trust and Catholic University. Is that accurate? Is that who funded your chair?
My understanding is that Leonard Leo, through the Marble Freedom Trust, directed funds that funded the chair. I think that's accurate.
And with respect to your chair, Mr. Blackman, $1 million was given to fund it through an anonymizing organization called Donors Trust, which has been called the ATM of the far right. Do you know who was behind that Donors Trust laundered donation?
I appreciate the question, Senator. I would direct all these to my college to answer.
I'm sorry, first of all, your mic's not on.
No, I appreciate the question, Senator. I direct all these questions about this to my college. Thank you.
My question is actually to you, and it's whether you know. Do you know who was behind that donation?
I appreciate the question. Anonymous gifts are as they are, and I appreciate all those questions directed to my college.
Your college can't answer what you know. This is a question to you about what you know. This is a Josh Blackman question. Do you know who funded your chair?
I've answered the question.
Yes or no?
Thank you, Senator.
You can't say this. Do you realize that if you were an expert witness in a judicial proceeding, I'd be entitled to know who was funding you because it goes to bias and conflict, correct? That's basic sort of hornbook trial practice, right?
Fair enough, Senator.
I'm right about that. You'll agree.
We were invited to testify about nationwide injunction and the like. This is not something I was prepared to testify about, so that's my answer for today.
Okay. Well, at least we know who funded Professor Alessia, and you won't even answer what you know. Let me turn to Professor Shaw. Let's just say that this activity today is designed to whip up more animus against courts, and that it adds to the atmosphere of threats that the court is now experiencing. I think we're up to, is it 162 threats to judges, which is pretty impressive. And a lot of this has the appearance, at least to me, of looking like it was orchestrated, looking like it was instigated, looking like there are folks behind it. So presumably, the Marshal Service should be not just protecting the judges and their family members, but also investigating the sources of the threats. Can you tell us what some warning signs would be that the Marshal Service has been directed, perhaps by the Attorney General or perhaps by some other senior official in the Department of Justice, to not do proper investigations, and particularly not look into orchestration or any effort to gin up these threats?
Senator, I have no information. It strikes me that a non-response to your queries or queries from other members of Congress to the Marshal Service or to the Department of Justice are concerning. There should be an active dialogue between the branches about something as serious as the security of the third branch. And I guess I would just echo what Senator Booker was saying earlier. I mean, there have been two relatively recent periods when bipartisan legislation was passed to improve judicial security after the tragic murder of Judge Solis's son, and also after the attempted attack on Justice Kavanaugh. Judicial security measures on a bipartisan basis quickly passed Congress, and I would hope that this is a moment in which broad agreement could be reached that it's necessary to do something similar.
And if it appeared that those were part of a larger plan or conspiracy, it would be appropriate for law enforcement to look into the question of whether there was a larger plan or conspiracy, correct?
Absolutely.
Thank you.
I would note that Senator Whitehouse asked two of the three witnesses about private donations given to their respective law schools, but somehow omitted Professor Shaw. And I guess I would ask Professor Shaw, are you aware of what's been publicly reported in disclosures that your employer, the University of Pennsylvania, from 2013 to 2019 received from Communist China $67,618,610. Have you seen those public reports?
I'm sorry, Senator, I have not.
Well, they are publicly reported, and $67 million from Communist China. If we're going to just clarify the record, let's clarify the record across the board.
If I may, I actually don't hold an endowed chair, so I don't have an endowed chair personally, so I don't think I was being singled out for any reason, but that I don't have one.
Penn.
I do work for Penn, yes. Yep.
Chairman Schmidt.
Thank you. I suppose to further the analogy that Senator Whitehouse gave of reffing a game, I don't think anybody has a problem on this side of the aisle with a ref calling balls and strikes or calling a foul. The problem is, what if the ref's daughter hired the coach? What if the ref has money on the game? What if people start to question the legitimacy of the ref in the game? We all know what happens. People don't watch it anymore. Vegas takes the game off the board. So it gets to sort of this question of, as I referenced in my opening statement with Hamilton, the reason why it's supposed to be the least dangerous branch is it relies on the other two branches for enforcement. And the court, the Article 3 branch, should be very well aware that if they lose legitimacy, they're cooked. And that's why we're having the hearing. Because people are questioning, how does Judge Boasberg, and I would actually ask you, Professor Blackman, pose this as a question. How in the world does Judge Boasberg get a case when he's not the emergency assignment judge, he's on vacation in the middle of the night? How can that happen?
I don't know, and perhaps even more significant, if you read the transcript of the case, he basically told the plaintiffs to change their case. They brought it one way. He said, no, here, plead it this way. Okay, good. Now I'm going to certify class and issue a ruling and go tell the plaintiffs around. He basically litigated the case on behalf of the parties. This wasn't merely a passive bystander. He was an active participant.
It's a statistic impossibility, and I want to I referenced what had been going on in the Eighth Circuit. 10 of the 11 appellate judges in the Eighth Circuit appointed by Republicans. Amazingly, Judge Kelly ends up on all the politically sensitive cases on a panel. It's not possible, except for the clerks there in that office, or the people that work for the clerk's office, are populated by her former clerks. So these are the kinds of things that this isn't just a new phenomenon. This is a concern about activism on the bench that's existed for a long time. It's just now on steroids. You talked briefly, and I mentioned it too, sort of Rule 23 as a more viable option for this, limiting limiting the orders to the parties, the rulings to the parties before the court as a case in controversy. Those are ways to address this. Are there any other structural suggestions that you have? And I also want to pose this to Professor Elisei as well.
Sure. I think one urgent need is to think about automatic stays. When you have district court judges granting universal injunctions and they don't stay their rulings, there's this frantic race to the Court of Appeals and to the Supreme Court, and the executive branch is not capable of actually changing policy on the fly, and that gives rise to these attempted contempt proceedings. I would think about if a universal injunction is granted or a nationwide class is granted, stay the ruling for 24 hours, 48 hours, some limited period till he's taken appeal to the appellate court, and don't let the judge just ruled against you decide whether appeals to be taken. I think the automatic stay will go a long way to addressing these issues.
Professor Elisei?
I think beyond Rule 23 and the enforcement of Rule 23, it's important to address the scope of injunctions not just through the non-APA route, but also through the administrative procedure route under Section 706. So I think that to the extent that we're going to really address the problem overall, you can't just address universal injunctions that are done outside of the context of administrative action, but also through the process that the APA sets up for challenging agency action.
Thank you. Professor Blackman, I do want to, you recently wrote an article in May of this year where you state the District of Maryland's standing order, that judge that automatically blocked deportations upon filing a habeas petition without merit review is pretty clearly designed to thwart the Trump administration's immigration policies. Could you explain that?
Yeah, this is unusual. So the District Court of Maryland issues what's called a standing order, which is basically an order that applies in all cases. And it says, by virtue of filing a habeas petition, a grant of stay is automatically issued. The Supreme Court has said there's a four-factor balancing test to decide whether a stay must be granted. This is automatic. Indeed, if you actually read this seriously, it's a permanent handcuff on the president's authority to deport people. The judge actually walked it back about a week ago. They sort of modified it. Maybe the Judicial Conference got wind of this. But I think there's still an attempt to limit the executive power in ways that have not been done before.
And it was issued to the government, I think it was writ large, right? I mean,
Yes.
This is very unusual.
Right. It wasn't notice given in each case. It was by virtue of posting on a website. This rule applies universally. There's actually a rule that says any ordinance you put on each ECF docket, it can't be done globally.
I think so one of the points of this hearing, the Supreme Court has a case in front of it where it has an opportunity to rein this in. And I think the Chief Justice is very keen to understand the perception of the court. It seems to be a good opportunity, I think, probably for the Supreme Court to finally weigh in here. Thank you. Senator Welch.
Just a couple of points I want to make. Number one, the effort to get universal injunctions has been pursued by litigants, including some of the attorney generals who serve on this committee. I know you did, as Attorney General, got several sought several universal injunctions.
Since you referenced the vast censorship enterprise of the Biden administration that a court declared was perhaps the biggest offense to the First Amendment in the history of the country, where there were named parties that were specifically enjoined. You mean that case?
Yeah, I do. My point here is that if there's an opportunity out there for a litigant, whether it's a lawyer trying to get the judge that he or she thinks is going to be the most favorable, or an attorney general trying to get the most relief for something that he or she believes in, they'll do it. So it's up to us if we think that process should be adjusted to change it. But it's not a Republican-Democratic deal. I mean, it's what litigants do. The second thing is, Professor Blackman, you mentioned how some of these universal injunctions inhibit the authority of the executive, right? What's the problem with that? I mean, what's so great about the executive having unlimited authority?
Well, I'll take the Alien Enemies Act in particular. This is a statute that's been around for 200 years. It's been enforced in various times. And historically, it's been a very deferential statute. The courts haven't scrutinized when it should be enforced, and they haven't told plaintiffs to turn around. So I think we're seeing not only aggressive use of the universal injunction, but also intrusions upon the executive authority.
So I get that. And let me just be clear. I disagree with you. And I disagree with the executive invoking what I regard as a very discredited law and using it to deny due process. So I'm on the side of pushing back against executive authority. So I don't see that as a big problem. Professor Shaw, one of the things people here are talking about is the class action. Mm-hmm. And here's my question with it, and I want you to address this. I had a small town law firm, and I'd have people who walk in, and every once in a while they had a hopeless case that we'd take, and we'd get them relief. And if I had to do that in a 4-person law firm and certify a class action, I couldn't have taken that case. So this so-called remedy of using the class action means that those Vermonters or those folks in Washington State or wherever who go into a lawyer's office to seek relief and that lawyer's willing to take the case, what are the burdens on that law firm if they have to certify it as a class?
Yeah, I mean, it seems to me that, let's take maybe the birthright citizenship example, arguments that challenges can be maintained against this executive order, but they have to be done using the class action device. I'm not sure if those are being made in good faith. Rule 23 of the Federal Rules of Civil Procedure has relatively demanding requirements. The Supreme Court has ratcheted up those requirements in a series of cases in the 2010s. The plaintiffs have to be similarly situated in terms of their injury and the kinds of relief that they are seeking. And the Solicitor General in the Supreme Court a couple of weeks ago didn't disclaim the likelihood that they would be back before the Supreme Court saying, well, you shouldn't even be able to certify a class with respect to this executive order. So it feels to me like a little bit of a heads we win, tails you lose. You can try a class action and we will marshal different kinds of arguments against you doing that. But it is not as though it is very easy to satisfy the requirements of Rule 23. And I think that shifting from these injunctions to a pure Rule 23 based regime would disadvantage those unable to secure representation, who don't satisfy the requirements of class membership, and would mean no relief from government unlawful conduct.
Yeah, and that's one of the things that's so important, hopefully to all of us, is access to the courts for an everyday person in Missouri or Texas or whatever. So you get some lawyers who are just willing to do it because it's a neighbor, it's a friend, it's a cause they believe in. I want them to be able to act and bring that case to court and not have to go through the incredible expense. On the question of universal injunctions, I mean, are there some suggestions you have or forum shopping that you have that would expedite or address what you perceive to be some legitimate problems that aren't siding with the partisan divide on this question?
Yeah. Thank you for that question, Senator. I do think that single judge divisions, which allow plaintiffs to, with absolute certainty, ensure that they will receive a particular judge when they file in a particular division of a district, are an enormous problem, right? That forum shopping is not exclusive to these single judge divisions, but it is the most serious kind of forum shopping. And I should say, as of, I think right now, none of the orders against the Trump administration have issued from judges who sit in single judge divisions, unlike some of the orders issued against the Biden administration. But I do think that the Judicial Conference has already endorsed a proposal that would essentially eliminate these single judge divisions. I think that's something that we should all be able to get behind.
Thanks. Well, I'd be willing to work with my colleagues on some of these practical questions and practical answers where we strip out whether we agree or disagree with the particular decision that's been made by the court. Thank you. Thank you all.
Professor Shaw, you said Congress had set high standards in Rule 23 for certifying class actions. Why would we have set high standards for class actions?
So I don't think I said that, sir. Just that the Rule 23 standards are relatively demanding, that the court has ratcheted up the difficulty of satisfying them.
So, but why would we set demanding standards for class actions?
I'm not sure. The Rules Committee produces the rules, so I'm not quite sure.
But Congress adopts them.
Yes. So, I mean, you tell me, sir.
Well, there's a reason we have high standards for class actions, because it should be difficult to certify a nationwide class. And what we are seeing is single judges ignoring the federal rules of civil procedure, ignoring the rules Congress has set out for class certification, and saying, I'm just going to issue an injunction to the whole damn country, and it doesn't matter if it meets even the bare thresholds of the federal rules. Senator Kennedy.
Would any of you advise a client to defy a federal court order?
No.
None of you would? How about you, Professor?
I mean, under most circumstances, we follow the government and private parties follow court orders. I suppose it's not, I would not rule out ever the possibility that in a sufficiently egregious order, there should be some consideration of whether there's a way.
So in some cases,
I think it's a qualified answer, yes.
In some cases you would.
In an extremely narrow band of cases, I think it would be considered, yes.
Okay. Do any of you think that nationwide or universal injunctions are not being abused?
I'm not sure what if I may, Senator, I'm not sure what the time horizon of the question is. I don't think that there could be good faith disagreements about the correctness of some of them, but I have not seen in the last 4 months abuse. No.
I've read your stuff and I've read your writings, and I don't want to get bogged down with this, but I have little respect for your opinion because I've read your stuff. When someone is in the White House that you agree with and someone gets a universal injunction against him, you don't like universal injunctions. You called them judges acting like they're politicians in robes and judges looking like crass political actors. But now that President Trump's in the White House, who you dislike, you think that universal injunctions taste like pumpkin pie. So I have to discount what you say because I think you act on your political beliefs. And I worry that that's what you're teaching your kids. So I'll leave you out of that. Do you think nationwide injunctions are being abused?
Certainly, Senator. I think that is.
They're being abused by both sides, aren't they?
Yes, Senator.
Both Republicans and Democrats are forum shopping, aren't they?
Certainly.
Professor, do you disagree with that?
I think both sides are abusing them. I agree.
Okay. Both sides.
Yeah.
There are no clean hands here. Now, your suggestion is that when a federal judge issues a nationwide injunction, there should be an automatic stay and an expedited right of appeal. Is that right?
Yes, sir.
Do you disagree with that?
I haven't given enough thought to have a position on it, Senator.
I suspect, Professor, your answer will be it depends on who's president.
No, Senator.
Let me ask you about this. What if we had a rule? I was reading an article the other day. I'm not suggesting it. I just want your opinions. That said, if a president, any president, issues an executive order, let's say, that clearly violates settled Supreme Court precedent, that a federal judge can't issue a nationwide injunction. For example, if a federal a president issued an order that said no one in America has right to counsel any longer, including but not limited to, in a felony case, having the government pay for your lawyer if you can't afford it. That clearly violates settled Gideon v. Wainwright. In that case, a judge has no authority or does have authority to issue a nationwide injunction. But in a case where the law is unclear, a judge should refrain from that. Now, obviously, we'd have to trust our judges, but we're supposed to be able to trust them anyway. What do you think about that?
I don't agree with that, Senator, because I think universal injunctions transgress the limitations under Article 3, even if the underlying merits are clear.
I happen to agree with you. I don't think there's any basis under Article 3, under Supreme Court precedent, under the English common law for nationwide injunctions. I think politicians have helped judges, and many judges are politicians, to just make it up. And many of them are like Professor Shaw here. If they like the president, they're against nationwide injunctions. If they don't like the president, they're for him. Professor, let me ask you this while I have you. On April 22nd, 2024, you said there are some members of the Supreme Court that are evil. Which justices were you talking about?
I'll take it your word, Senator. I don't recall using that word, but.
All right, here's what you said. You were talking about the majority opinion in Muldrow v. City of St. Louis. You said, quote, Justice Kagan, will she be able to control the opinion's future distortion by her evil colleagues? Probably not, end quote. Who were you talking about?
Sir, I'm very skeptical. If there's a transcription, it was probably a transcription error. I do not think I said.
No, you said it. Why don't you own up to it? Which you call some of the members of the Supreme Court evil. Now, which ones do you think are evil?
I would have to refresh my recollection. I've been very critical of some members of the Supreme Court.
You're embarrassed that you made that statement, aren't you?
I'm
You're an officer
it doesn't
of the court.
Sound like something that I would say.
You know what I'm embarrassed at? That you're teaching our kids.
I don't refer to Supreme Court justices as evil in the classroom,
on
sir.
Your podcast, April 22nd, 2024.
Okay, well,
big as Dallas. And you're an officer of the court, and you're here advising us to be respectful to federal judges, and you say they're evil members of the United States Supreme Court? Gag me with a spoon. You're part of what's the problem in all of this.
Thank you, Senator Kennedy. Senator Durbin.
So I'm going to give the panel members an opportunity to respond to a question posed by Justice Sotomayor during the oral arguments on the birthright citizenship bill. And she said, I'm paraphrasing, imagine a new president takes office and decides, because of the epidemic of gun violence in our country, to issue an executive order announcing that he will deploy the military to seize the guns of every gun owner across the country. That executive order would be swiftly challenged in a federal district court, or more likely in several district courts. Should a district court be allowed to issue a nationwide injunction to at least temporarily prevent the enforcement of that executive order? I'd like each of you to respond. Professor Blackman.
I actually addressed that point in a blog post. We actually have history of someone in this country disarming everyone. His name was General Gage, and that was not fought with Rule 23.
So your answer?
If the president can't take everyone's gun in this country, I don't think the remedy would be in the courts.
Professor Shaw?
Yes, I think that whatever the constitutional right is, whether it's a Second Amendment, a First Amendment, a due process right, if a president tries to do something that is in clear violation of settled law, whether we like the law or not, that an injunction is an appropriate remedy.
Professor Alicia?
No, Senator. I've written in support of the Second Amendment in many fora, but I don't think that a judge could issue a universal injunction under those circumstances. Of course, the challengers could seek certification under Rule 23 and then try to pursue class-wide relief.
So do you think it's reasonable to expect every single person affected by an executive order like the one I described to seek relief through Rule 23, or to file their own lawsuit to seek relief?
I don't think that would be necessary, Senator. If you had one person who sought class certification successfully, that would be sufficient. But even if you had failures to class certification, once you get to the Supreme Court and the Supreme Court issues a binding decision, that precedent would bind all the lower courts. So it's not a question of whether you get to a uniform rule, it's just a question of when you get to a uniform rule and by what route. But those limitations on the route matter under Article 3.
There's been a lot said during the course of this hearing about the possibility or likelihood that judges are being selected for this process to review the decisions of the Trump administration on a political basis. Professor Shaw, I noted, I'm not sure you read this into the record, but you said according to a recent analysis by Professor Bonica, the Trump administration has lost 80.4% of the time before district judges appointed by Democratic presidents, 80.4 Democrats, 72.2 before district judges appointed by Republican presidents. Who is Professor Bonica?
He's a political scientist at Stanford, and yeah, so that's in my written statement. And I think it does suggest that it cannot be reasonably just attributed to policy antipathy. This is about a pretty broad consensus about the lawlessness of many of the administration's actions, and I think both Democratic and Republican appointees have seen that.
That's my impression as well. This is not a stacked deck, a statistical impossibility. It is a fact. This president has issued more orders with more controversy than any president in recent memory. I have only been to Amarillo once when I was a younger person. I'm sure it's a lovely city, but it turns out that the Amarillo division of the Northern District of Texas has gotten quite a bit of publicity. It turns out that there are people have been filing lawsuits there because there's only one judge who sits in that division. Judge Matthew Kaczmarek, who I remember appeared before the committee. Litigants knew Judge Kaczmarek would be assigned to their cases and viewed him as favorable to their arguments. So the argument that's being made that venues shopping, forum shopping, is on one side of the table. It is clearly on both sides of the table, and Judge Kaczmarek is pretty well known for the way he rules. Professor Shaw, if you have any observation on that?
Yeah, I mean, as I said in response to Senator Welch, I actually think that those single judge divisions, like the one in Amarillo, Texas, where Judge Kaczmarek sits, are a genuine problem. But none of the injunctions against the Trump administration have issued from judges who sit in those single member districts. So I'm not even sure it's fair to say that that's a problem we are seeing now and we saw previously. We actually aren't seeing it now. But I do think that regardless of who the president is, these single judge divisions are a problem that Congress would be well served to address.
Thank you very much. Thank you, Chair.
Thank you. Senator Hawley.
Thank you very much, Mr. Chairman. Mr. Chairman, it's great to have this hearing. Thanks for calling it. Thanks to all of our witnesses for being here. Professor Shaw, nice to see you again. Let me just start with you, if I could, Professor Shaw. You talked about the fact that there have been lots of rulings against the Trump administration. That's absolutely statistically true. I disagree with almost all of them. In fact, I think all of them. But the issue of this hearing really isn't the rulings, is it? It's the remedies. Would you agree? And those are distinct things. You may think that the ruling is quite correct, but that's actually not what we're talking about here today. We could have a hearing on that. Maybe we should. But we're talking today about the remedy. And the question is a remedy that binds parties who are not before the court, is that an appropriate thing? I mean, aren't you concerned about judges binding non-parties in their remedies? You may love the ruling, but even if you do, don't you think it's a little bit anomalous for courts to be going out there and binding parties who are not before them? I mean, is that something we want to encourage?
Senator, I think that judges have been issuing rulings that impact non-parties since Marbury versus Madison, right?
So you're not concerned about it?
I'm not. I absolutely think that they can be abused, and they have been abused.
Wait a minute. You were very concerned about it just a couple of years ago.
Yeah.
You said in response to a nationwide injunction on the Biden FDA's mifepristone rules, and I quote, "This injunction's a travesty for principles of democracy, notions of judicial impartiality, and the rule of law."
I think I've been consistent today. That was issued by Judge Kaczmarek in a single judge division. They're a problem. Those are a problem.
With him personally? Wait.
No.
Your testimony is if it's issued by Judge Kaczmarek, it's bad?
No, sir.
It's personal?
That is not my testimony.
Is the problem with the injunction? You were criticizing the universal injunction
issued by a judge in a single judge division. I've been very clear today that those are a problem.
By a Republican judge in a Republican division, then it's bad.
No, Senator.
Otherwise, it's fine.
No, Senator. I think that single judge divisions
What is the
are a problem.
principal difference? I'm looking for a principle. I understand you hate the president. I understand you love all of these rulings against him. You and I both know that's not a principle. You're a lawyer. What's the principle that divides when issuing a nationwide injunction is okay, when it's not? When the Biden administration was subject to nationwide injunctions, you said that they were travesties for the principle of democracy. You didn't say the referral to Judge Kaczmarek was a travesty. You said his injunction was a travesty for principles of democracy. Yeah. So, in other words, the translation is just you didn't like the outcome. Is that right?
No, Senator. Look, we're talking about, I don't think Article 3 precludes this form of relief. So we are talking about prudential considerations.
Prudential meaning political?
No.
Then
no.
give me, so far I have yet to hear it. You've been questioned by multiple senators. I have yet to hear a principle other than the fact when you like the ruling, you think it's great to apply it nationally, including non-parties. When you don't like the ruling, it is a travesty for the principles of democracy, notions of judicial impartiality, and the rule of law.
Look, Senator, I'll say, I think I am self-aware enough to know that my view of the underlying legal question, I am sure colors my perception of the remedy. I think that we should all acknowledge that. And yet I do think
and
that
why shouldn't we stop nationwide injunctions for everybody?
I think
That's what we're talking about today.
Because I'm not willing to leave without relief non-parties who are
you're
injured.
not willing to leave without the ability to bind President Trump.
No, I think that...
I mean, when it's Biden, it's okay. No. When it's Biden, oh, it's a travesty. When it's Trump in office, it's no holds barred, whatever it takes, right?
I believe in a powerful...
What was it that President Biden's staff said? We've got to do undemocratic, unconstitutional things to save democracy. Why is this the same
I believe
thing?
in a powerful president. I do believe in presidential power, but power and constraint are not at fundamental odds.
What is the principle?
Power.
What is the principle? The legal principle. You've referenced prudence. You've referenced the judges you don't like. What's the principle of when an injunction binding non-parties, which was never done in this country before the 1960s? And let's see the chart, the Trump chart, which was done really only once Trump came into office for the first time. You don't think this is a little bit anomalous? You don't think that's a little bit strange?
A very plausible explanation, Senator, you have to consider is that he is engaged in much more lawless activity than other presidents, right?
You don't think
you must
this
that as a
was never
possibility.
used before the 1960s, and suddenly Democrat judges decide we love the nationwide injunction, and then when Biden comes to office, no, actually.
It's Republican appointees as well, Senator, and the 1960s is where some scholars sort of locate the beginning of this.
Can you identify
but others,
one before then?
Mila Sahoni, who's another scholar of universal injunction, suggests 1913 is actually the first, and others in the 20s.
The Republic endured for 150 years before there was a nationwide injunction.
Well, the federal government was doing a lot less until 100 years ago. So there's many things that have changed in the last 100 or the last 50 years.
So long as it is a Democrat president in office, then we should have no nationwide injunctions. If it's a Republican president, then this is absolutely fine, warranted, and called for. How can our system of law survive on those principles, Professor?
I think a system in which there are no meaningful constraints on the president is a very dangerous system
That's
of law.
not what you thought when Joe Biden, that is not what you thought when Joe Biden was
every
president.
president
You
is
said that is
constrained
not what
and
you
must
said.
be.
You said it was
Absolutely.
a travesty for the principles of democracy, notions of judicial impartiality, and the rule of law. You also said
the Supreme Court, Senator, agreed 9-0 with me on that
You also
case,
said when Joe Biden was president, you said the idea that anyone would foreign shop to get a judge who would issue a nationwide injunction was just judges looking like politicians in robes. Again, it threatened the underlying legal system. People just trying to get the result they wanted. It was a travesty for the rule of law. But you're fine with all of that if it's getting the result that you want.
Sir, the Supreme Court agreed unanimously with me in that case, right? There was no standing. The case should never have been allowed to proceed. And the combination of parties without standing and the single-judge division.
No. We're talking. No, they did not. They did not issue a ruling on the nationwide injunction. You criticized the injunction nationwide. Listen,
issued in a case where no one had standing.
Here's the thing. We've now gone 6 minutes, and Senator Kennedy had you for 6 or 7. You couldn't identify a single principled basis. We all know the truth here, which is it's not just you. It's most of my colleagues over here on this side of the aisle, who I respect a great deal, and they were raising very principled objections to the nationwide injunction just 6 months ago, maybe 9 now. And you're probably right. My point is that all that's changed in 9 months is the occupant of 1600 Pennsylvania Avenue. And I realize that my colleagues on this side of the aisle very much dislike that individual, and I realize that you think that the rulings that he has lost are fundamentally sound. We might grant all of that. I disagree with all of that, but we can put that to one side. The question we're talking about here is, should judges, single judges, district court judges, be able to bind non-parties who are not in front of them? And you used to say no, now you say yes. Let's be consistent. I would just suggest to you our system of government cannot survive if it's going to be politics all the way down. Thank you, Mr. Chairman.
Can I briefly respond?
Sure.
I mean, you invoked democracy a couple of times there, Senator. Judges are part of our system of democracy. Democracy is not as simple as majority rule. Judges have always served something of a
You would have it be as simple as
function.
majority rule. When you get the majority you like, you're for the nationwide injunction. When you don't, you're not.
Senator Blumenthal.
Thank you, Mr. Chairman. I'm going to give you the opportunity that I often found absolutely precious when I was arguing before a panel of judges and couldn't get my answer out. I'm going to give you some of my time to just say what you were going to say to Senator Hawley.
Thank you, Senator.
I can't interrupt you.
Okay, thank you, Senator.
I'll take some of your time.
I started to say this.
By the way, we're good friends, so it's not personal.
Well, maybe I'll just finish what I started saying at the end, which is in a number of the questions today, there has been this embedded premise that there's something democratically troubling about judges issuing these nationwide injunctions, constraining the democratically elected president. And I guess I would just say in response that, we have a constitutional democracy, so the people are sovereign, and that's, the sovereignty flows from the people, and we do choose our elected representatives, but obviously we choose our representatives in Congress. Congress passes statutes, the president signs them, and many of the rulings we are talking about were predicated on executive branch violations of statutes that Congress passed. So the rulings in many ways are about protecting and reinforcing democracy. And then finally, I'll say that, courts are part of our democracy, right? They have served this rights protecting and democracy facilitating function from basically the beginning, whatever the original design of the Constitution was. And it is not undemocratic or anomalous for courts to sometimes strike down acts of the president or of Congress when they conflict with the fundamental law, which is the Constitution, which in our system, courts have long had the primary role in enforcing.
And in fact, just as a footnote to this conversation, Congress has an obligation to follow the Constitution too, correct?
Absolutely. The president does, Congress does, every official state and federal takes an oath to uphold the Constitution, but where that oath does not appear to be fully honored by one or more other actors in government. Sometimes courts do need to step into the breach. I think that is what we have been seeing.
And I can't remember exactly what that chart said, but so far in the lawsuits that have been brought, the administration or the president has lost, I would say, a vast majority of times. Is that correct?
The vast majority, yes, Senator.
And I want to ask a somewhat open-ended question because I have to confess, as Attorney General of the state of Connecticut, I probably succeeded, I can't name in which cases, obtaining a nationwide injunction. Then Attorney General Schmidt sought more than...
You started it. Is that your admission?
Sought more than a dozen nationwide injunctions against the Biden administration. Then Attorney General Moody also sought numerous nationwide injunctions. This is a tactic, and it's a well-founded one, that attorneys general, litigants, and others have used again and again and again. And it shouldn't be a partisan issue. Nationwide injunctions shouldn't be a partisan issue. And when I say they did it, I'm not being accusatory. I confess I did it. And I don't know about then Attorney General Whitehouse. He can speak for himself, but it should not be a partisan issue, should it?
I agree that it shouldn't be, but of course, yes, it has been. I mean, I think that despite the somewhat heated exchange I was just having with Senator Hawley, I do think that we don't want judges to be sort of driving the train of policymaking, and there are absolutely, there may be points and there may be contexts in which it does feel as though some fundamental change to the way judges consider nationwide injunctions, how much there's some critique that the merits have become the entire analysis and that there should be some prescriptions that are different about the kinds of harms that should be, the way harm should be evaluated or assessed. So I do think there are, again, back to the sort of prudential point, there are absolutely reforms that I think that there could be some...
Just to take, and I apologize for interrupting, but I am running out of time.
Yeah, sorry.
To take Senator Hawley's point about looking for a principle, a jurisprudential lodestar here. maybe we do need some refinement on a bipartisan basis to provide some guidelines to district court judges, some of whom come to work on their first day and are presented with litigation that determines whether or not kids get health care or whatever in parts of the country they've never visited, in towns they don't even know how to pronounce.
Right. So, and whether that comes from a rule change, Supreme Court guidance, something legislative, I am not sure, but I think there could well be bipartisan consensus around clearer standards that guide judges asked to consider requests for nationwide injunctions.
And that would probably increase the credibility of what courts do if they could point to standards that were not just personal preferences or whims or, perhaps subconscious political leanings.
I agree with that, Senator.
Thank you. Thanks, Mr. Chair.
Thank you. Senator Blackburn.
Thank you, Mr. Chairman. Professor, I do want to come to you, and I want to return to the conversation about calling the Supreme Court justices evil. You host a podcast, correct?
Yes, Senator.
And that is called Strict Scrutiny, correct?
Yes, Senator.
Okay. You made those comments on your podcast. And Mr. Chairman, I would like to submit the recording of that podcast for the record.
Without objection.
Thank you, Mr. Chairman. In that podcast, you referenced, as Senator Kennedy said, to Justice Kagan, an opinion, and you referred to the conservative justices as, and I'm quoting you, her evil colleagues. That is something you said on Strict Scrutiny in your podcast. And you, in that same podcast, you made a reference to Justice Alito. Do you recall that?
I don't recall that. We certainly do reference Justice Alito, so I believe that, but I don't recall specifically
your comment
what.
There was that he was an abject misogynist. So since this is your podcast that you hosted, and this was your opinion on that podcast, would you like to provide explanation about why you think conservative justices are evil and why you would think Justice Alito was a misogynist? Do you care to explain yourself?
I would have to look at the transcript, Senator. I think that the dismissive approach to sex equality arguments in the Dobbs case was deeply concerning. One paragraph in the opinion suggests that there's no sex equality problem with abortion restrictions or prohibitions. I think that's deeply wrong. And in the more colloquial sort of mode of a podcast conversation, that is probably what I intended to convey, that he discounted very serious sex equality concerns.
You were angry and you let your emotions get the best of you, is basically what you're saying.
I don't think I'm saying that, Senator. I was having a conversation, and I am sure I was criticizing Justice Alito. We frequently do on my podcast.
Okay. Would you call that lack of respect?
As in the context of a podcast, we frequently, I will stipulate that we frequently demonstrate a lack of respect for writings of the Supreme Court justices.
That is good to hear that from you, that you have that admission of guilt. So thank you for that. I've got a question for the entire panel. There was discussion about Section 1507 and protesting outside of judges' residences, justices' residence. And I've got a bill, the Protecting Our Supreme Court Justices Act, and it would deter intimidation of Supreme Court justices. And in the exchange Senator Cruz had earlier, he referenced that purposeful intimidation. This would change, it would increase the maximum term of imprisonment for violation of Section 1507 from 1 year to 5 years, and increasing the maximum time, jail time for a protester under 1507 is, I think, an effective way to deter this intimidation of our justices. So I'd like to hear from each of you on this. Professor Blackman, I'm going to come to you first, and then just a very quick, short answer from each of you.
Sure. I think it's a good idea, and I think it should be enforced vigorously as well. We mentioned Judge Kaczmarek before. He's had several death threats against him. They resulted in plea bargains. So I think there's a serious problem that needs to be addressed with enforcement.
Okay. Professor Shaw?
You know, I think that any law that also touches protected First Amendment conduct would need to be scrutinized carefully, so I would need to take a look. I'm not prepared to take a position here.
Outside of a...
No, this is about protest outside of protests or
intimidation.
Okay, so violence, absolutely. I mean, if we're talking about increasing penalties for violence, I would absolutely support that. Yes.
Okay, great. Professor?
I certainly think we need to carefully scrutinize the level of violence and the threats against Supreme Court justices and other judges, as we saw when there was a threat against Justice Kavanaugh's life, right? An attempted threat against him and his family. So it underscores the seriousness of the issue, and I think it's important for Congress to take a look at this.
Thank you. Thank you, Mr. Chairman.
Thank you. Senator Hirono.
Thank you, Mr. Chairman. I kept hearing one of my colleagues accusing you, Professor Shaw, of disliking nationwide injunctions only when it is applied to Democratic presidents. He tried so many times. That is not what you said. That is certainly not what I heard. What I heard you say was in those instances where there's a single judge in a district, that can lead to foreign shopping, judge shopping, which is exactly what happened in Amarillo, Texas. And you said that is something that Congress could address. I think that is a fair depiction of what you testified to. Is that correct?
Thank you, Senator. Yeah, that was in my written testimony, and I think that I did confirm it today.
So I had introduced a bill to Stop Judge Shopping Act, which would require suits seeking nationwide relief against the enforcement of federal law to be filed in the D.C. District Court. And I explained at the time that I introduced the bill that this court, quote, hears the large majority of cases involving challenges to federal agency action, and its judges are experts at deciding these cases impartially, end quote. That is one of the ways that we can address the issue of foreign or judge shopping, which you did address once again today. Correct?
Yes, Senator.
Yeah, I wish we could take that bill up. So, you know, this attempt of my colleagues to continually attack the Democrats as somehow not wanting judges who decide cases based on objective facts, application of the law, as opposed to having some kind of ideological axe to grind is really more something that they have a problem with, apparently, than anything that we Democrats stand for. Once again, Professor Shaw, there was a suggestion today that case assignments in D.C. is happening in a way that is statistically impossible. And I think this only serves to point out that maybe the person who made this allegation doesn't have enough awareness of statistics or hasn't read the rules in the way cases are assigned in D.C. Do you have any response to the allegation that someone is stacking the decks against the Trump administration in this court, in the D.C. District Court?
Right, Senator. So I've heard both that critique that Judge Boasberg is getting a disproportionate share of the cases, and also the kind of opposite critique that the motions panels in the D.C. Circuit have been more favorable to the Trump administration than random chance would produce. You know, statistically unlikely events do sometimes occur, and I think it very unlikely that there is anything untoward resulting in the assignments either at the District Court or the Court of Appeals level here in D.C.
I have to thank you for pointing out how many cases, there have been over 200 cases filed to stop this president from, in my view, abusing his power and engaging in illegal acts. And frankly, and I think Mr. Blackman also suggested this, as did you, Ms. Shaw, that if we don't like this president to be sued, then we in Congress should enact laws that allows him to do whatever the hell he wants. So why don't we let him ignore the appropriations of this Congress? Why don't we let him stop certain grants from being issued? Why don't we let him go after Harvard and any other school that he doesn't like? Why don't we let him go after law firms that take positions that he doesn't like? Why don't we let him do that if we don't want him to get sued? I think that's a rhetorical question, but certainly we could do that. Thank you, Mr. Chairman.
Thank you. Senator Schiff.
Thank you, Mr. Chairman. Michelle, I wanted to ask you about some of the threats we're seeing on the judiciary, but let me preface it by quoting the president, who has called federal judges who rule against him communists. He's called them lunatics. He's called them monsters. He has said that they hate the United States. Of course, he called for the impeachment of Judge Boasberg, said the court system is radicalized and incompetent. His advisor, Stephen Miller, has threatened to suspend the writ of habeas corpus if judges essentially don't fall in line. And as a result, we're seeing judges' lives threatened and their family members' lives threatened. Let me start with a threshold question in terms of a president making these personal attacks on judges for ruling against him, or the policies against the policies of the administration. Have we any experience in our history with this? I mean, there have been presidents, of course, who've been deeply disappointed in judges they've appointed, and of course, many of these judges ruling against Donald Trump or people appointed by Donald Trump. But have we ever seen a president make these kind of sustained and personal attacks on members of the judiciary?
Senator, look, I would say that obviously tension between, sometimes very heated tension between elected officials and judges, presidents and judges who rule against them is nothing new. But I agree with you that there is something different about the tenor of the rhetoric that we are hearing today. And I think that some of the specific suggestions, and maybe I'll offer a couple of examples. One, I do think that including family members of judges in the attacks on judges' rulings is something that, to my knowledge, we have not previously seen members of public office engage in. The proposals to impeach, right? So there's been rhetoric, but also actual resolutions introduced in the House to impeach federal judges for the substance of their rulings is also something that I don't think we've seen. We've obviously impeached federal judges before. That's a constitutional remedy for very serious misconduct, bribery, corruption. Obviously, if the judges engage in treason, bribery, and other high crimes and misdemeanors, impeachment is the remedy. But we've never seriously entertained the possibility of impeaching judges for the substance of their rulings. And so I do think that those threats represent sort of a new escalation that is deeply concerning.
Well, I would certainly agree. I tried one of those judicial impeachment cases of a judge named Porteous, and it was for bribery and other like serious offenses. Certainly not for upholding the law or the Constitution or having a different view of the law or Constitution than a president. In terms of the family members, it's not just the president's criticism, but at least while he was serving as a special employee, Elon Musk was pushing out these threats against members of the Judge Boasberg's family, I think tweeting out or retweeting content identifying who the children are or where they work. And that is just amplifying the danger to these family members. Tell us a little bit about this phenomenon now of people sending pizzas to judges and the implicit threat in that.
Well, I mean, I think it's this is also something that I don't think we've seen before, right? There is clearly some kind of coordinated effort to seek to intimidate federal judges and their families by sending pizzas, communicating the message that their residence, their addresses are known. And some of the pizzas bear the name of the murdered son of District Judge Esther Salas from New Jersey. And the message there, I think, is a very clear one of very serious threat. And I think judges are taking that threat, and the marshals are as well, from the reporting that we've seen, very seriously.
And last question. If you could help Professor put this in the broader context for us, because this attack on judges and the judiciary isn't happening in isolation. We've seen the president now turn on Leonard Leo because these ultra-conservative Federalist Society-approved judges are not proving too right-wing enough for the president. But this comes in the context of the administration also going after law firms. It seems very much a part of a concerted effort to attack the rule of law and using the law to defend people's rights. Tell us a little bit about the broader context.
I do think that attacks on judges and attacks on law firms are of a piece. They seem designed to seek to neutralize sources of countervailing authority and opposition to this administration. And if law firms can't take on unpopular causes because they are scared to run afoul of the president, and if judges are scared to rule against the president, then we really have lost any meaningful check on a president. And as I said in my opening remarks, I think if the Constitution is committed to a single principle, it is limits on power, right? No absolute power. And I worry that we are on a path toward few, if any, meaningful limits on the president.
Thank you for your testimony today and for speaking truth to power.
Thank you.
Thank you, Senator Schiff. I will also note that when it comes to rhetoric against judges, that it was Democratic leader Chuck Schumer who stood on the steps of the Supreme Court and threatened the justices by name, and one of many left-wing commentators who's amplified that message is a fellow named Ian Millhiser, who, when the leak of the Dobbs opinion happened, he tweeted out, quote, "The draft Roe opinion appears to be as bad as expected, but I'm glad it leaked because this leak will foster anger and distrust within the irredeemable institution that is the Supreme Court of the United States." And I guess he decided that rhetoric was not overheated enough, because then he tweeted, quote, "Seriously, shout out to whoever the hero was within the Supreme Court who said, F it," although he did not abbreviate that, "let's burn this place down." That is the angry, unhinged language from the left that has been directed at the court when they dislike the decisions. I want to thank each of the witnesses for joining us today. I want to thank Senator Schmidt for co-chairing this joint subcommittee hearing. Written questions for the record can be submitted by senators up till June 10th at 5 p.m., and the witnesses are asked to respond to any written questions for the record by 5 p.m. on June 17th. And with that, this hearing is adjourned.
This hearing of the Subcommittee on Delivering on Government Efficiency will come to order. Welcome, everyone. Without objection, the chair may declare a recess at any time. I recognize myself for the purpose of making an opening statement. Good morning and welcome to another DOJ Subcommittee hearing where we will highlight more abuses of your tax dollars. The left has funneled hundreds of billions of federal tax dollars through non-governmental organizations, NGOs, to push destructive policies and line the pockets of their friends and allies. This NGO scheme demonstrates massive waste and abuse of federal resources. Today's hearing will bring transparency for the American people. We will expose the corrupt ties that bind left-wing NGOs, Democrat elected officials, Democrat political appointees, and the deep state bureaucrats who write grants and contracts. Corrupt backdoor deal-making has exploited the taxpayer purse to achieve policy ends opposed by the very Americans forced to fund them. Whether by pushing green energy scams or facilitating the resettlement of millions of illegal aliens into American towns and cities, the alliance between big government and allied NGOs has been highly effective and has been flying under the public's radar for far too long. But today, we are going to draw back the curtain. The scheme works in a cycle, as shown here. Democrat administration officials work with leftist NGOs to implement programs in a manner that ensures those NGOs receive massive grants and contracts. The leaders of those recipient groups then turn around and donate to Democrat political campaigns. This intricate web of connections is how elected and appointed Democrat officials and allied NGOs work together. Federal agencies fund the NGOs, and the NGOs shape the agency's behavior. It can be hard to tell where the government ends and the NGO begins. The nonprofits essentially serve as an arm of the government. To put it another way, if the permanent bureaucracy is the de facto fourth branch of the government, then these leftist NGOs are the fifth. Our witnesses today will describe how the left has funneled hundreds of billions of U.S. tax dollars through NGOs, discuss the destructive policies this has enabled, and detail the damage done to our country. So-called green energy NGOs are among the worst offenders. They have used federal dollars to destabilize the U.S. power grid and energy dominance, while raising energy costs on Americans. The Biden EPA steered billions in U.S. tax dollars to leftist climate NGOs via a $20 billion slush fund known as the Greenhouse Gas Reduction Fund, GGRF. Like-minded nonprofits were enlisted to implement President Biden's Green New Deal scam. While we are grateful to the Trump administration and EPA Administrator Lee Zeldin for shutting it down and quickly terminating these grants, further accountability is necessary. The full Committee on Oversight and Government Reform is investigating Biden's GGRF. We know that all the awardees are connected to both the Biden administration and Democratic donors, and that they sit on each other's boards in an incestuous circle. Today, we will shine light on this dynamic. Take, for example, who the Democrats choose to bring in as their witnesses. Someone so entrenched into the system that she was a director of the U.S. Department of Housing and Urban Development, a leader of a housing organization that lobbied for more federal spending, and now a nationally renowned nonprofit leader who donates to Democrat campaigns. Other examples include many green NGOs that employ former Biden administration officials. These people wrote the rules for this climate grift in which they now partake. As government officials, they were paid by taxpayers to conduct the grift. Now taxpayers are funding the grant awards that pay their salaries. This cash grab was so large that some nonprofits were birthed solely to get in on the game. One newly created nonprofit, Power Forward, received an astonishing $2 billion from Biden's EPA, despite having just been formed. Power Forward is now part of a network tied to Rewiring America, which employs Stacey Abrams, the twice-failed Democrat candidate for governor in Georgia, and voting rights activist. After all, however, she would have been a good hire given her history of running her own nonprofit, which spent $3.2 million on campaign resources instructing voters to support her campaign, all of which are prohibited actions for nonprofits. Consequently, her nonprofit was levied the largest penalty ever imposed in Georgia's history for violating state campaign finance laws. This is the circle of life. Climate and energy is just one area where the entrenched bureaucrats and political appointees have partnered with NGOs to do the left's bidding. Illegal immigration is another. Federally funded NGOs have egregiously abused tax dollars to fund the invasion at our southern border by providing housing, transportation, legal services, and more to shepherd illegal aliens across our border and settle them in our country. These NGOs support the cartels in their mission to invade our country. Under the guise of assisting migrants, these groups have placed criminal networks, dangerous gangs, and human traffickers into American towns and cities. Think about this. The American people's hard-earned taxpayer dollars have been used to literally import rapists, murderers, and terrorists from around the world straight into our communities. Where were these NGOs when 22-year-old Laken Riley was violently murdered by an illegal? Where were these NGOs when 12-year-old Jocelyn Nungare was brutally raped and murdered by one of these illegals? And where were these NGOs when 20-year-old Kayla Hamilton was raped and strangled to death by an illegal? Where were these NGOs over the weekend when the illegal alien launched Molotov cocktails into a crowd in Boulder, Colorado, intentionally injuring a dozen Americans in an anti-Semitic attack? I'll tell you, they were continuing to receive taxpayer dollars to import more of these illegal alien monsters to commit more heinous crimes against our people. Many Americans are familiar with the more egregious offenders. These include Catholic Charities, which raked in over $2 billion during Biden's 4 years, and the Lutheran Immigration and Refugee Service, which received over $221 million in government grants in fiscal year 2023 alone. But many American taxpayers are still unwittingly funding this sort of illegal activity through the United Nations, which is the conduit for much of the funding NGOs use to resettle in our country. Americans are likely unaware that their tax dollars are funding UN efforts such as the cash and voucher program involving 624,000 illegal aliens crossing the border just last year. This $372 million program provides prepaid debit cards and cash in envelopes to illegal aliens to facilitate their movement to and through the U.S. border. The American taxpayer is funding groups that start the migration, the groups that show people how to cross the border by evading U.S. immigration laws, these groups that have been bused and flown illegal aliens, many of them dangerous, into America. Whether exploiting taxpayers to push illegal immigration or fake environmental justice, the left's NGO scheme seeks to destroy our country and fundamentally alter the American way of life. This ongoing waste and abuse of taxpayer resources must end. The Trump administration is turning the tide, and today's hearing is intended to expedite the effort to drain these slush funds dry. If we don't, Democrats can't wait to return to power and continue funding their NGO friends through slush funds and stop deportations. Keep these illegal alien criminals in our country, and of course, fund the Green New Deal scam again. And with that, I yield to the ranking member Stansbury for her opening statement.
All right. Well, good afternoon, everyone. Welcome indeed to the DOJ subcommittee. It's always an interesting journey here. Madam Chairwoman, before we get started, I want to take a moment to observe that this very subcommittee was created in January to act as the congressional tip of the spear for DOJ and Elon Musk's efforts inside the federal government, which our GOP colleagues were falling all over themselves to get in on the action. And in fact, I don't know if you know this, Madam Chairwoman, but one of your own GOP members who couldn't get on the committee actually contacted me to see if I could help because they were so desperate to participate in this activity. But here we are. I feel like we should play a breakup song in the midst of the breakup of the GOP with Elon Musk and DOJ, and yet still the zombie lurches on. And you know, I think it's interesting that people are barely saying his name in these halls, and this subcommittee barely has any credibility at this point. And Elon Musk still hasn't appeared under oath in front of this committee or any body here in Congress. And in fact, Donald Trump himself apparently asked his own aides this week if DOJ was, and I quote the president, bullshit. Donald Trump asked if DOJ was bullshit. Meanwhile, our friend Mr. Musk is going crazy on Twitter. We just checked. He's still going at it. And he literally has been tweet storming the GOP for the last 24 hours. And he says, I'm sorry, but I just can't stand it anymore. This massive, outrageous, pork-filled congressional spending bill is a disgusting abomination. Shame on those who voted for it. You know you did wrong. You know it. And you know what I find interesting about his tweet is that he says, I'm sorry, I just can't stand it anymore. And I think, you know, the American people have been there for the last 3.5 months as they've dismantled the federal government, as Musk and Trump and his friends here have helped lay wake to the federal government, dismantling federal agencies, firing thousands of federal workers, stealing your private data, costing the federal government millions of dollars. And in fact, it appears that they may have actually cost more money than they apparently saved. So it's hard to take any of this seriously or with any credibility. Musk lied about Doge and its savings. The president and the speaker just this morning, once again, lied about the big abomination of the bill and the deficit spending in it. There was a misrepresentation of a witness in this hearing last time. There was lies about the budget, reconciliation, and yes, the Doge package, which was transmitted to Congress yesterday. And I don't think I even need to comment on the wild journey of baseless conspiracy theories that we just heard. So, it's very clear that Doge has made America less safe, less secure, undermined our global and national security, compromised our data privacy, impacted our ability to serve our vulnerable communities, and left the government in total chaos. And yet, many of these Doge brothers have implanted themselves inside of federal agencies and are now answering directly to the West Wing and to the Director of Office of Management and Budget, Mr. Russell Vought, who, by the way, is testifying just across this campus on his bill for the FY26 budget, which would eviscerate these programs. So I want to say, first, they came for our federal agencies. Then they came for our judges and law firms and the rule of law. Then they came for the free press and your freedom of speech. Then they came for higher education and our children. Then they came for congressional offices. And now, here they are, coming for civil society and nonprofit organizations. What are nonprofit organizations? Food banks, legal aid clinics, homeless shelters, organizations that are the glue of our communities. In fact, right now, they are withholding $500 billion illegally from nonprofit organizations that provide services for our communities. Public safety, health services, housing, the big brothers and big sisters of America, Boys and Girls Club and Habitat for Humanity. Is this the dark money scare that we're hearing across the aisle? I think all of us understand what these organizations do in our communities. But let us be clear. The actions that are happening here in this committee and which the administration are trying to execute through executive actions, through letters, and yes, sending Doge employees baselessly and illegally into nonprofit organizations are illegal. They lack moral authority and they lack legal authority. The truth is simple. Neither the president nor any other executive branch official has the power to unilaterally revoke an organization's tax-exempt status or to use these authoritarian tactics to try to intimidate our nonprofit and civil society organizations. And we will dive deeper into that topic and your rights during this hearing. But if my colleagues across the aisle want to talk about dark money networks, we can look no further than this very hearing room, because if we actually want to understand the dark money funded networks that are making the government run right now, let's talk about Project 2025. The witnesses who are here today as part of the organizations that helped to craft it. Mr. Vought, who was at the helm as the architect of that document, and the folks who are inside the federal government right now, dismantling our agencies and attacking every aspect of our democracy. We will not stand for it. And with that, Madam Chairwoman, I yield back.
Without objection, Representatives Gosar of Arizona, Moskowitz of Florida, and Presley of Massachusetts are waived on to the subcommittee for the purpose of questioning the witnesses at today's committee hearing. I'm pleased to introduce our witnesses today. Scott Walker is the president of Capital Research Center and an expert in investigating how nonprofits spend money and get involved in politics and advocacy. Mark Krikorian is the executive director of the Center of Immigration Studies and is an expert on the issues of immigration and border security. Daniel Turner is the founder and executive director of Power the Future and an expert in energy and environmental issues. Diane Yentl is the president and chief executive officer of the National Council of Nonprofits. Again, I want to thank Ruth, so help you God. Let the record show that the witnesses answered in the affirmative. Thank you. You may take a seat. We appreciate you being here today and look forward to your testimony. Let me remind the witnesses that we have read your written statements and they will appear in full in the hearing record. Please limit your oral statement to 5 minutes. As a reminder, please press the button on the microphone in front of you so that it is on and the members can hear you. When you begin to speak, the light in front of you will turn green. After 4 minutes, the light will turn yellow. When the red light comes on, your 5 minutes has expired, and we would ask that you please wrap it up quickly. I now recognize Mr. Walter for his opening statement.
Thank you. Chairwoman Green, Ranking Member Stansbury, distinguished members of the subcommittee, thank you for the honor of testifying. I'm president of the Capital Research Center, where we study nonprofits every day. Americans are proud of our nonprofit sector, which has long led the world because they love real charities that actually help people here and abroad. They don't think of the nonprofit sector as the plaything of billionaires and politicians. Yet, all too often, that is the reality of our non-governmental organizations, or NGOs. Far too many NGOs are really BGOs, basically government organizations, for 2 reasons. First, they get most of their money from government, not citizens. Second, they serve the big government political agenda that fights to centralize power in Washington for the benefit of the left's preferred political party. From countless egregious examples, consider the Solidarity Center. This nonprofit child of the country's largest union federation, the AFL-CIO, is chaired by the AFL-CIO's president. Solidarity Center doesn't just boost unions, it also champions DEI and climate justice. It's suing the current administration because DOJ recommended its federal gravy train end. It received over $86 million from the federal government since 2008. 61 of that $86 million was given under President Biden, doubtless encouraged by the 3 Solidarity employees who went into the Labor Department. Solidarity receives 99% of its revenue from American taxpayers. It serves the AFL-CIO, which gave 86% of its 2024 political donations to Democrats. Today's Democratic witness, Diane Yentl, is yet another powerful example of nonprofits serving big government. One of her typical tweets attacked DOJ and defended the Vera Institute of Justice, which in 2023 received 79% of its revenues from government. It's a hard-left, Soros-backed group whose priorities oppose the views of Americans' Democratic majority by advocating soft-on-crime policies and defending illegal aliens. Its biggest vendor in its last IRS filing was Blue State Digital, which began life as Barack Obama's digital campaign team and now serves the entire left. Ms. Yentl was hired by Obama at HUD, and President Biden considered her for a cabinet post. Her previous job was leading the National Low-Income Housing Coalition, an NGO that advocates for ever more federal spending by HUD and uses identity politics to justify its agenda. In her current job, leading the National Council of Nonprofits, Ms. Yentl quickly sued the Trump administration over budget cuts. What lawyers did she turn to? The Democracy Forward Foundation, whose board includes President Biden's notorious chief of staff, Ron Klain, and is chaired by Mark Elias, the Democratic super lawyer. Ms. Yentl claims the Republican tax bill would have handed, quote, unchecked power to the Trump administration to punish nonprofit orgs that don't fall in line with its ideology by labeling them as terrorist-supporting groups. Nonsense. As an honest left-leaning law professor explained in the Chronicle of Philanthropy, quote, a despot seeking to silence nonprofits would be weakened, not empowered by the legislation. No wonder nonprofit expert Bill Shambra warned that Yentl's partisanship at a major nonprofit membership group may erode public support for nonprofits by suggesting, quote, nonprofits are just like any other major institution of American society, fighting fiercely to maintain the status quo against necessary reforms. It's understandable, though not admirable, that status quo nonprofit leaders are scared by DOGE examining their government funding. They'll use an Urban Institute study designed to scare you members of Congress with statistics like government grants support nonprofits in every congressional district. No one explains why it's wonderful that so many nonprofits are as dependent on government cash as a meth addict is on methamphetamine. The same study stresses how larger nonprofits especially hoover up tax dollars. But while big nonprofits are often less effective at helping people compared to smaller neighborhood groups, they certainly are more powerful at lobbying government in the service of bigger government and the left. They're also great at suing government. This politicized pseudo-charity aimed at bloating government and seizing political power goes back decades, as when the Obama administration took money from Catholic charities and gave it to Planned Parenthood. This is a simple, ugly story of tax dollars, cronyism, and political scheming camouflaged by invoking the moving stories of the real heroes of America's charitable sector. Please don't fall for the sob stories.
Thank you, Mr. Walter. I now recognize Mr. Krikorian for his opening statement.
Thank you. During the 4 years of the Biden administration, the United States devoted significant taxpayer funds to facilitating illegal immigration. There's been much reporting about the role of NGOs in this process after the illegal immigrants crossed into the United States. But what the center has examined is what happened before the migrants got to the Rio Grande. In other words, how NGOs and UN agencies were paid by U.S. taxpayers to facilitate the illegal movement of migrants through South and Central America and Mexico. We've documented a large UN NGO support network from field reporting and annual reports from this group called the Regional Refugee and Migrant Response Plan. This network consisted of way stations all along Latin American illegal migration routes that made it possible for millions of foreign nationals from as many as 180 countries to illegally get to the U.S. border, in part funded by U.S. taxpayers. Some of these funds were provided directly to NGOs by the State Department's Bureau of Population, Refugees, and Migration, or USAID. Other funding was sent indirectly through our funding of UN agencies, which then in turn funded NGOs. This often was described as merely humanitarian assistance to people who would travel anyway. But in reality, this amounted to a coordinated, well-funded assistance designed to undermine U.S. immigration laws. Starting in South America and Central America, NGOs handed out millions of dollars worth of supplies designed to assist recipients in their plans to illegally breach the borders, not just of the United States, but of half a dozen countries along the way. Just a couple of examples. In Colombia, in northwestern Colombia, the center found NGOs working in coordination with a paramilitary drug smuggling group called Clan del Golfo, also known as the Gaitanistas, which controlled the smuggling routes in those areas. To get an idea of how this worked, there's a town in northwest Colombia called Necoclí, which is a major staging area for migrants trying to cross the Gulf of Urabá to get to the jumping off point for trips through the Darien Gap. Well, our researcher went to Necoclí and found what amounted to kind of a swap meet or farmer's market of NGO groups with booths of UN and NGO organizations there to provide assistance. Just a couple of examples, the Florida-based NGO Cadena was set up in a booth next to the Silver Spring-based Adventist Development and Relief Agency, and there were many other US-based and overseas-based groups there. And they provided a variety of services, assistance on how to make it through the Darien Gap, food, dry socks, backpacks, etc. When they crossed that Gulf of Urabá, they're still in Colombia, and they get to the village of Acandi, which is where you jump off to go to the Darien Gap. And there, the NGO UN group, the camp, was in a was in a camp where the security for the camp was provided by this drug smuggling gang. In other words, and it's not clear to us, we don't have evidence of this, but it seems likely to me that NGOs and the UN paid for the security by paying this drug smuggling gang for security for this jumping off point. After they pass through Central America, they get to southern Mexico, cross from Guatemala into southern Mexico, and there, Tapachula is the town that is the first place you get to. And what we found there was a large, kind of a one-stop shop illegal immigration mall where the UN agencies and the NGOs were supposed to be housing them. This was under construction when we went last fall. And it was only one of many similar camps. There's several in northern Mexico as well. Especially curious in Tapachula was an NGO funded by the UN, which means funded by the US, which provided repressed memory therapy for illegal immigrants who had been rejected for asylum by Mexico, which they do in order to be able to make it through Mexico without hassles. They had been rejected. They went to the repressed memory therapy and got a certificate that they had forgotten about the persecution they had suffered, and now they remembered it, and so they went to their appeal and they got their asylum status. So throughout Latin America, these networks funded in part by US taxpayers have made this flow of illegal immigrants possible. And yet oversight has remained absent, and Congress has not cracked down and insisted that recipients of funding not engage in promoting illegal immigration.
Thank you, Mr. Krikorian. I now recognize Mr. Turner for his opening statement.
Madam Chairman Green, Ranking Member Stansberry, good afternoon, and thank you for the opportunity to appear before the committee today. Three words often heard in tandem with DOGE are waste, fraud, and abuse, and I hope my testimony can shed light on the third word, abuse. I started my organization, Power the Future, to advocate for energy workers in rural America, and it has come to light that on the other side of that fight, the climate movement received billions from taxpayers, and that is the abuse I wish to highlight. The 2022 Inflation Reduction Act set aside hundreds of billions of dollars for the green agenda. The Environmental Protection Agency received tens of billions. As reported by the Washington Free Beacon, a staffer from an environmental group called the Coalition for Green Capital named Jahai Weiss joined the Biden EPA to direct $27 billion in green funding. For context, $27 billion is larger than the budgets of the Departments of Treasury, Interior, and Commerce. Yet Mr. Jahai went through no confirmation process, and his decision to direct tens of billions to organizations of his choosing had no congressional oversight. And conveniently, under his tenure in this new EPA role, $5 billion was granted to his former organization, the Coalition for Green Capital. The abundance of green dollars created a new pernicious mechanism: create a group for the sole purpose of getting government grants. For example, Power Forward Communities was only a few months old when it applied for and received nearly $9 billion to distribute at its own discretion. And one lucky recipient was an organization affiliated with two-time Georgia gubernatorial candidate Stacey Abrams. With only $100 in the bank, this group received $2 billion. Yes, it is legal to create a nonprofit, to get IRS accreditation, apply for and receive government grants, but it is fair to question the process and demand transparency. What does the application for a $9 billion grant look like? Particularly when an organization has no staff, no history in the space, no office, and is only a few months old. A Department of Defense grant of this size would have layers of transparency. A Department of Transportation grant that size would require a bond to guarantee deliverables. Yet it seems that in the name of climate change, unvetted, unelected, unconfirmed bureaucrats require no safeguards. And this is the precedent of pernicious funding. Any future president can announce a slush fund, appoint loyalists to dole it out, and anyone can create a group to get government billions if they know the right people, bypassing that pesky thing called Congress. In his recent Senate hearing, Secretary of State Rubio said, DOGE uncovered, for every dollar spent at USAID, only 12 cents was actually received in aid. The rest was spent on overhead, high salaries, dinners, events, travel, raising awareness. You can call it overhead, a better term is grift. But this funding scandal is far worse in context. For at the same time the Biden administration was generously rewarding climate groups with billions, they enacted the most radical energy agenda in history, which punished the American people. Making energy expensive made life expensive. And we saw under the Biden administration record high inflation, skyrocketing price of energy, gas, utilities, food, and consumer goods. It was bad enough to dole out billions, but to do it to the very groups making America unaffordable was a new low even for Washington, D.C. And unless this Congress changes the laws, the mechanisms are still in place to appropriate new funds using a new crisis, forming new groups, skirting Congress, and ripping off the taxpayers. Last week, my organization sent letters to this committee and Attorney General Bondi calling for an investigation into the Biden administration use of AutoPen on green executive orders, asking if Biden himself directed them or if the staff took leniencies. A very severe accusation, but made even more plausible in the light of this hearing: abuse. Abuse of the purse, abuse of the pen, also that climate groups and their political allies could benefit. This is the very worst of Washington, and why the American people have such little trust in government. For our nation to survive, Congress must restore trust in government, end the slush fund abuse, stop the grift, and it is my sincere hope that my appearance here today can help begin the process. Thank you, and I look forward to your questions.
Thank you, Mr. Turner. I now recognize Ms. Yentl for her opening statement.
Chairwoman Green, Ranking Member Stansberry, and members of the subcommittee, thank you for the opportunity to share how America's charitable nonprofits serve communities across the country. From small towns to big cities, in every congressional district and state, nonprofits feed, heal, shelter, and nurture people of all walks of life and every political persuasion. From hospitals to libraries, churches to food banks, from veterans to school children, artists to researchers, charitable nonprofits touch and benefit all Americans all our lives.